what do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God!
As you can see, we've had our eye on you for some time now, Mr. Anderson. Mr. Anderson. Oh, Mr. Anderson. 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 Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson. Mr. Anderson.
Mr. Anderson.
Mr. Anderson.
Mr. Anderson. Mr. Anderson. Mr. Anderson.
Before the
Don't get brazen with me.
Good morning, good afternoon, good evening, everybody. How are you? It is me, Legal Vices, and you are here with Legal Vices. It is St. Patrick's Day, and I am already drunk AF. We're settling in for a good stream today. Sorry, I was a little bit late. I've been liquored up and drinking over on Meme Copium stream. We've been having fun, and then I had to make a cocktail because it's St. Patrick's Day. The Irish half of my body, well, the Irish, like 25% of my body, is screaming for release. So this should be a very interesting trial stream today. I'm glad you're all here. We've got a lot of stuff planned, and by a lot of stuff, I mean just playing the trial and reacting to what's going on there. I'm so glad you are all here. Christy L says, oh, I called this one. This is going to be fun. All right. Yeah, exactly. This is going to be a Drunk Rax is in the house. Absolutely. We're doing good. We're doing good. The trial, we just have the face of whoever the hell this guy is. We just have this guy here. Dun, dun, dun. Bad oil painting of this guy. That's all we have so far. So, all right. Let's pull this out. That's what she said. All right. St. Patrick's Day here in Korea. It is 11:01 p.m. It is after. It was just, well, hell, we'll get to that in a bit. Let me do a bunch of back of the house housekeeping stuff, and then we'll bring up the one guest that is already in chat. First of all, this happened so long ago I can't pull it up and show it, but Aspen Fallen says, suddenly craving battered maple leaves. If you watch Meme Copium stream, you know. Deep fried battered maple leaves are the shit. Wendy Reitler, newest member of the Clean and Sober crew, welcome to you. Thank you so much for being here. I deeply appreciate the support by becoming one of my members. Everybody wants to be a Legal Vices member. You all can be my member. Everyone should be my member. My member loves you all, and you all love my member. But also, taking that away immediately from her is King Ginger, who is also a new member of the Clean and Sober crew. So it only lasted a very, very short time. Well, again, that's what she said. I'm sorry about that. But King Ginger, our newest member, after our newest member. So now King Ginger is our newest member of the Legal Vices Clean and Sober crew. Thank you so much for being here. And what else have we got here? Samuel Reynolds has popped the cherry on the super chats this evening with the Mr. Anderson, you should have used protection. I don't even know what that means, but okay. I agree with you. All right. And again, here we are. It is Friday night. We have 1,000 people here waiting for this trial to start. And we have 478 likes. Not even half of you hit the like and subscribe button. Come on, people. Do your job. Get in there. Smash that like button. Smash that subscribe button and do it because that's what you want to do. We need to get it seems to be like 600 likes is where YouTube starts sending out its little tendrils of, hey, there's something happening over here. People are liking this, so go over there and check it out. We start getting recommended right about 600 likes. So hit that like button. Let's keep the like button going. And if you haven't subscribed, I would deeply appreciate your subscription as we go along, because that's what we're doing. We're trying to get to 36,000 subscribers by the end of tonight. That is the goal by the end of this week, to get to 36,000 subscribers. And where are we right now? We are at currently, let me bring up the number on ye oldie phone. We are at 35,749. So basically 250 new subscribers is what we need today to get to 36,000 subscribers. And already my Whoop fitness tracker is telling me it's time to go to sleep, but it can go intercourse itself because we are here for the long haul with the trial tonight. And after you hit that subscribe button, make sure you're subscribed. If you're already subscribed, please just double check to make sure you're still subscribed, because YouTube likes to delete subscriptions for some reason because they're massive cucks. So hit the like and subscribe button and then go and take the like and subscribe poll. The poll today is, as always, rather lame and stupid, but it's the best I can do under pressure. I hit the subscribe, but we're focusing on subscriptions right now. We want to get to 36,000 by the end of today to make the goal. So mods push for subscriptions today. That's what we want. We want to get to 36,000 by the end of the day. I hit the subscribe button, and the like button too, because this is an awesome channel. Or you hit the subscribe button and the like button too, because you meaning me, because I'm mildly entertaining. And I hit the subscribe button to get you to 36,000 subs, or I hit subscribe button and the like button too. XOXO V-Bear. All right, that's the like and subscribe poll. Hit the like button, hit the subscribe button, take the poll, do stupid shit, because that's what we're all about as we start this day here. This is day 13 of the Zachariah Anderson trial. And by all accounts, the state should be ending. We're going to do the recross of this current witness who's just like Mr. Nerdy police detective guy. They're going to be redirecting him, and then we should have maybe one or two recross questions, and then we will have the obligatory break where the defense will make a motion for a dismissal of the case because the state has failed to prove even remotely beyond a reasonable doubt that the defendant is guilty. And as always, the judge will say, sorry, no, motion denied. And then we'll go into the defense case. That's what we're looking for. So hopefully we'll be able to get into the defense's direct case, their case in chief, during the morning of today, because I don't want Hayden to have all the fun. Hayden's going to take over around the lunch hour. I don't want to let him have all the fun. I want to have some fucking fun around here. All the cool stuff happens in the afternoon. Chaos Coordinator 666. Great. All right. So here we are. That takes care of most of the back of the house stuff. Again, the gist of the back of the house stuff is hit that subscribe button. We're pushing subscriptions today. And the like button is secondary, but it's also great. Again, about half of you, or a little more than half of you, hit the like button now. Come on, like button. It takes literally like 0.2 seconds to go down there and bam, click the like. And speaking of people we like, back by popular demand, it is Niklas Starow, union rep, labor law guy. Woo!
Hey! Oh.
The general consensus is you are funny as fuck and you need to be back. So you're back.
Thank you. And it's because of you and the chat who gives me bad ideas.
And what we've got going here today, it's St. Patrick's Day. So, I seem to be yelling into my microphone. My microphone is possessed by the spirit of Satan and keeps adjusting itself. I need to figure that out. I thought I had it figured out. But we have what is called, today is St. Patrick's Day in everywhere around the world, but mostly from Ireland. So that is why we are wearing a green hat. This is a hat from Aran Sweater Market in Ireland. And this is a gorgeous hand-knit wool sweater from Ireland, from the Aran Sweater Market in Ireland. But this frostbite, Okay, I keep yelling into the microphone. Got to stop that so it doesn't automatically adjust. This is my Cthulhu Frost Pipes pipe shirt from my Finnish pipe maker friend, Frost Pipes. But it's green, so I'm wearing it. And I even have a green pipe for tonight. And we're down to the watch. We're doing this full thing. This is a green watch from Ireland that a percentage of the proceeds go to the Ireland, which is essentially their lifeboat rescue group, which is essentially their Coast Guard of Ireland. This is put out. This is a great little watch. I love this watch. It's super fun. And go to nomadicwatches.com if you're interested in supporting the Irish Royal National Lifeboat something. I'm too drunk to remember. But we're going full Irish. We're going so full Irish. We have the Irish Storm cocktail, which if you want to play along at home, the Irish Storm cocktail, this is a double, by the way, is just the single is 40 centiliters, or like about an ounce and a half of Irish whiskey, 10 milliliters of Aperol, 10 milliliters of Cointreau, and 1 egg white, shaken and foamy. So this is a great cocktail. It's the Irish Storm, and this is made with Bushmills. Delish. And that's what we've got on tap tonight over here. Because it is St. Patrick's Day, we've got a bottle of Bushmills. This was full about an hour ago, so that tells you what's going to happen tonight. And we haven't popped the seal on the Redbreast 12-year yet. We'll have to find a reason for doing that. All right, that takes care of the obligatory. Like I said, I'm 25% Irish. My father's family is Scottish English. My mother is her mother is Lithuanian and her father is Irish. So I'm 25% Irish, but today is St. Patrick's Day, so I'm 100% Irish. And there we go. So we've got everything. We are full Irish tonight, and we're also pickled herring Swedish.
I managed to find the only thing green in my closet, and it's not the Hulk. It is simply what I wear when I'm driving the combined harvester. And yeah.
Why do you drive the combine harvester in like April, March?
Well, I use it when I do it. I'm not doing it now. This is the only green I have, and the only connection I have with the Irish is probably my ancestors went over there to say hi.
Rape and pillage. To say hi.
Yeah. But
the Vikings went over to Ireland to say hi.
Yeah. Hi! Get down! No.
The Vikings went to Ireland to say hi. Hello.
That's a fancy religion you have there.
You're correct.
Let's destroy it.
And we're not doing a recap today because literally nothing happened yesterday, by the way, in case you were wondering.
Oh, yeah.
Nothing happened yesterday. It was a very normal day in court. The Vikings went to Ireland just to say hi. Hello. Hello, Irish people. That is the funniest shit I've ever heard in my life. The Vikings went to Ireland just to say hi.
I knew I couldn't say all the other words, and my mind blanked totally. Hi.
I'm trying to like flag some of these chats, and I can't because I'm laughing too hard. My hand won't stop shaking. Hello, Irish people. Hello. Hello.
Can we park here?
Christ.
Oh,
Oh God, my rib. I'm doing an ab workout already. Oh Christ. Oh my God. Hey KB, I don't get this joke. Essentially, like right around 1000 AD, the Vikings just went and literally graped and pillaged everyone in England and Ireland. That's kind of the story. The end. In actuality, they just raped and pillaged the entire country, and we're just joking about them just stopping in to say hi. Oh my Jesus.
I saw the chat here. Hey, I'm Irish and DNA shows I'm Norwegian. Yeah, I wonder why.
I said, like 3/4 of my ancestor are Irish, Scottish, and Irish, Scottish, and English, but my last name ends in son, so that tells you I'm Scandinavian by DNA.
Well, I blame the Norwegians and the Danes. Swedish Vikings went for some stupid reason. Hey, let's go east.
Yeah,
where it's even more cold.
Not Wessex. No, see, and like I'm Mormon basically by birth and raising, and we do some serious genealogy. I can trace my lineage back to the kings of Wessex, and also back to Ragnar Lothbrok. I've done it. I can trace it all the way back there, and back the farthest I've been able to trace ancestry is back to about 420 AD. So I definitely, but I mean, we're probably all related to Ragnar Lothbrok if we just know the proper channels to get through.
That's not the way to talk about vagina.
Exactly, vagine is how it's pronounced.
Sorry. Yeah. Well, I can only trace my family back to the 11th century.
Yeah,
but it's not any Lothbroks. It's some wimpy nobility of sorts.
But I mean, if you just go like father, son, I can get back to about, I think, like 1480-ish, 1485-ish. But if you just like, when one branch ends, you go through the matrilineal and you just keep weaving your way back, then you can get back to, I mean, everybody's related to everybody eventually.
Yeah.
Oh my God. We just stopped in to say hi is the funniest thing I've ever heard in my life. Volpe Fox, thank you so much for the $2 super chat. Hi back, you Swedish shyster. You and your pickled herring. My mother used to just love pickled herring.
Yeah. And we do it for every time something is the biggest to celebrate with. Midsummer, pickled herring. Easter, pickled herring, because pickled herring and Jesus are perfect combination. In Easter, we have eggs and herring because we need to suffer.
Pickled herring and Jesus are the perfect combination.
But us Swedes are a really, really weird people when it comes to celebrate things, because we have split pea Thursday. Yeah. Because some king back in the day, we had an abundance of pea, not pea, but peas, and not we're not at war peas, but sorry for my English. But we had an abundance of peas, so we had to eat peas at Thursdays. Yeah, we are really, really weird people. We have such traditions that people go, huh?
Rich G says Jeff must be drunk.
So are we otherwise ready?
What was your first clue?
Mr. Anderson to come in, please.
Oh my Christ! All right.
Let's break this boring stuff up with some court time.
Well, they're going to bring the defendant in now. So, oh my God, this is the most Scandinavian thing I've ever heard. We'll see. Well, like we're sort of neighbors. Like I said, like 25% of me is Lithuanian, and like my grandmother, my Lithuanian grandmother, they left like just when she was a baby, right before the Bolshevik Revolution, and went to Chicago and worked in the stockyards and things. But she would always like make Lithuanian head cheese, which is basically just like smash a pig's head, boil it, and then you just like smash it into a big jelly block and slice it up into pieces. And they were big into like pickled herring and stuff, and just like, I mean, anything with bacon, potatoes, or like pickled flesh. So we're sort of kindred spirits that way. Oh. Nancy Joe M, thank you so much for kicking us off with this ridiculously large super chat question. I had audits going on, so I'm just catching up on this trial. Why is it a problem that the DA talked to the witness that caused a mistrial last time? What caused the mistrial last time was the prosecution did not turn over information and evidence to the defense, as they are required to do by law. They didn't turn over the fact that the witness, who was the court clerk in Wisconsin that was trying to hook up with the allegedly deceased guy, they didn't turn over the information that she went to the wrong house. Not his house. She went to the wrong house.
Would you come down, please?
They didn't turn over this important information, so it was a mistrial. And Wild Rose 1905 with a $10 super chat, who was, I think, the first one actually to do the super chats. Thanks for always keeping me entertained at work. Happy St. Pat. No. See, the Irish side of me is revolting at you. It's not St. Patty's Day, it's St. Patty's Day. Or anyway, yeah, same thing. St. Patrick's Day. St. Patty's Day.
St. Patrick's Day.
New member, thank you so much for becoming a new member, King Ginger. We already went through this. That's how drunk I am. I'm repeating chats already. Mr. Anderson, you should have used protection. Right. Samuel Reynolds, thank you so much for that super chat. And how do they say goodbye? It depends who you're talking about. If you're talking about Americans, we say goodbye. If you're talking about Koreans, they say it depends. Like Korean is interesting because if you are going and the listener is staying, you say something different than if the listener is going and you are staying. If you are leaving and the listener is staying, you say 안녕히 계세요, which is like please stay in peace. But if you're staying and the listener is going, you say 안녕히 가세요, which is please go in peace. What about Sweden?
Hej då. That's it.
Hodor?
Hodor.
Hodor?
Patrick's Day. And let's continue.
It's hey.
Presentation.
Hey, Dor. What's up? All right, we are continuing. Let's bring up the court feed.
Be my guest.
Pump up the volume. Pump up the volume. Oh, shit. That was funny. That was really funny. Thank you so much for that. This is why your people love you. That was the
Detective Korea. You were asked some questions by the defense about whether there were periods of times where any calls were missed, specifically by the defendant, specifically.
This is
redirect calls he did not answer. Do you recall that line of questioning?
Yes.
And do you recall that during the testimony in this case, the state's focus has been on a specific time period, which was May 17th.
That is an awesome Monty Python.
The evening hours from 7:34, around 7:34 p.m. to about 11:19 p.m. Do you remember that time period is a period that we have
that is a
focused
great
on?
Monty Python blast.
And so as to that time period on May 17th, are you able to indicate, based on your review of all the materials, is that a time period where the defendant, just as the defense mentioned in the time periods they asked about, where there were no phone calls answered on that ANS phone. Is that also a time period where that was true?
Yes.
But did you further review to see if any calls during that same time period, around 7:34 p.m. to 11:19 p.m., did you find that there were also no calls that were either made or answered on the Moto G6 phone during that period of time?
That's correct.
And did you also find during the time period we're speaking about that not only were no phone calls responded to on the ANS phone, but no phone calls were made on that phone as well during that time period?
Correct.
And then I'm going to ask you about texts. So as to any of the devices that you are aware of that the defendant possessed, were there any texts that the defendant answered or that his devices answered, or were there any texts sent out on those devices during that time period of 7:34 p.m. around to 11:19 p.m.?
There were not.
Now, were some texts received that were not answered during that time period?
On the ANS phone, yes.
Okay. And then finally, were some of the electronic devices, or at least one of the electronic devices the defendant had, ones that could be utilized for internet searches?
Yes.
And as to the devices we've talked about, was there any evidence of any internet searches done by the defendant, again, on May 17th from 7:34 p.m. to 11:19 p.m.?
No.
Okay. So I'm going to ask those same kind of questions about not just the ANS phone and whether it missed calls, but about all those other ways that a person can show that they are aware, awake, involved, right? So I'm going to ask about all of those kind of devices as to, in response to what the defense asked you. So do you recall the defense asking you on May 5th from a time period that I think ended up being around 11:15 a.m. to 3:30 p.m.? Do you remember that being brought up by the defense?
Yes.
Okay. And your testimony was, based on the exhibit you saw, that it did not appear that any ANS phone calls were answered during that period of time. Is that accurate about what you testified to previously?
Not anus. It's not an anus.
Well, I believe there was
I'm saying
it
just
began and ended with calls, and then in between there were none. Correct.
Okay. And so that time period covered was 11:15 a.m. to 3:30 p.m. around, right?
I believe so. Yes.
Okay. So I'm now going to show you what's been marked as State's Exhibit 350, and this is regarding the Moto G6 phone.
You can almost see that ventriloquist hand
up his ass, just like jammed his hand up his ass, is like making his mouth move.
Blah 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 blah. Yes.
No, it's not an anus phone. ANS. Yeah, you don't smuggle it in through your prison pocket. It's not. It's not what this is. It's not a prison pocket phone. It's an ANS phone.
First, I'll start with the first page of State's Exhibit 350. Again, does this appear to be phone records regarding the Moto G6 phone, essentially the secondary phone of the defendant, covering the time period of that 11:15 a.m. to 3:30 p.m.?
Yes.
And during that 11:15 a.m. to 3:30 p.m., were any calls made on this Moto G6 phone of the defendant's? Did that phone make any calls out?
Yes.
And when did that occur?
That was.
I'm 12. That was funny.
2020 at 12:08:45 p.m.
Okay. And then were any texts made from this phone during that time period?
There was.
Okay, and that again was on this same phone, the Moto G6?
Yes.
And so when did this phone text out during that time period that counsel was referring to?
12:17:22 p.m.
And then
yes, clearly it means your husband is
web
hiding
history,
the body.
meaning this phone was used to access the web during that same time period between 11:15 a.m. and 3:30 p.m.
Yes, there's a web history beginning at 12:25.
Okay, so if you review that page and then on to page 2,
finding
can you tell when that
periods of 3 to
ends?
4 hours where there were no calls answered on one phone. But then again, they only had 1 month of material to go on. If they go on, they will probably find
We
other
don't
things.
just ask about the ANS phone. We ask about other devices. All of that was activity during that same time period. Is that correct?
Yes.
Okay. So let me, I think that you were also asked about a different time period, a May 10th time period. Do you recall being asked whether you saw any activity on specifically the ANS phone on May 10th from, I think it was around 3:48 a.m. to 1:30 p.m. You remember that time period being a time period you were asked to consider about whether phone calls had been answered?
I recall the times in the day. I don't recall the exact times, but I do recall being asked about that, yes.
And did you, but you weren't asked about whether, other than calls, whether there was any communication on any device. Is that right?
Correct.
Okay. So again, as to that ANS phone, did that phone also have the capacity to text out, at least on occasion?
The ANS phone?
Yep.
Yes.
Anus.
So I'm going to show you now what's
phone.
been, well, I'll just ask, did the ANS phone, I'll show you.
Exactly. That is exactly what they're implying. They can't say it because they can't prove it, but that's what they're implying. He stalked her. He stalked the girlfriend, so therefore he killed the boyfriend, chopped him up with the chainsaw, put him in the back of the truck, drove to Walmart, parked the truck way away from the entrance to Walmart with the body in it, bought some stuff, and
appears to be a text on the ANS phone during that time period that you were asked about.
Yeah. There's a baseball bat missing from the apartment, and the prison snitch said that he was killed with knife.
Does that appear to be a text that went out on that phone?
Yes, there's a text message on 5/10 of 2020 at 9:09:45 a.m.
Okay. Thank you.
You're welcome.
You were asked a question about a tip that has come in regarding a person in the proximity of Rosalio Gutierrez's patio on May 18th. Do you recall that?
Yes.
And what were any considerations you had about whether that should be followed up or whether it could be followed up?
There's no information to follow up with the person who had called on it. So we had really no direction as to who to follow up on. There are no video cameras located in that area of the apartments, or actually in the apartments at all. So there was nothing for us to follow up on that end either.
So he didn't do it. That's what you're saying, right?
Based on the existence of a number of cigarette butts, was Rosalio Gutierrez's patio in close proximity to an area where a lot of cigarettes were being smoked outdoors?
Yes, directly adjacent to his patio.
And was it heavily raining on May 18th?
We already did that one. Sorry. Go away. Go away.
The whole period of time it was raining. I can't say specifically during the middle of the day that it was raining heavily, but throughout those 3 days it had rained heavily, yes.
And did Rosalio Gutierrez
raining outdoors means that drag marks disappear indoors?
Sheltering.
I object to relevance. That's where the line of questioning is going. I think.
Was there some sheltering over the patio area of Rosalio Gutierrez that would be within a few short steps of where people were smoking?
So above his patio would have been the deck area of the upper apartment, the upper unit.
And how many steps would you estimate that was from where the smoking location appeared to be?
Oh, his patio is directly adjacent to where the grass area is.
You were asked about an area. I don't know if we ended up deciding whether it was 1 or 3 blocks, but a area that has a few trees or some trees that's in close proximity to Wood Creek. Do you recall that question?
Yes.
During all the time since Rosalio Gutierrez's bloody apartment was found, has there been any bodies or body parts that have turned up in that location?
No.
They haven't looked at all if it's dug down or anything.
Yeah, that was the thing he testified to yesterday. Was
and
they had the
we asked some questions about
investigation and the house investigation. They didn't have enough people to do both, so they just said, "Forget about the landfill. Let's just focus on the house."
Anderson tree farm. Were there work boots in any way associated with the grandfather?
Don't shave, Niklas.
I'm never gonna shave.
Don't shave.
Nope.
Never shave.
And also not at the lake house, the Belgium lake house from Miss Brown Williamson?
They were not.
And then what about at the defendant's home? Were there a separate and distinct pair of work boots that would have been grandfather related?
There was
grandfather
one pair of
related
work boots that was located.
And you were asked some questions about the missing persons database nationally and the ways that, that would be reflected officially, right? That
during that, I don't know, 3.5 hour period, he has to be driving over there, do all this, dispose of everything, drive back home.
That kind of database open. What would be
that's
your
an hour's
purpose?
drive. That's a narrow fit.
Without a database, there would be no way to determine if remains were located, to compare those remains through DNA or through whatever means to confirm that they may be related to, in this case, Mr. Gutierrez. So keeping that open, even though the case is going and has been referred, it gives the ability that at any point, at any time, if remains are located and there is a comparison made, that, well, Kenosha Police Department as well as the family involved would be notified of that. So without that database, we wouldn't have that ability.
Yesterday he was asked, is this the most evidence you have processed in your career in this case? And he said yes. And
yeah,
over 2,000 items we processed, and all I have is prison speech, a daughter, and a pin needle of maybe blood.
Now, I'd move admission of States Exhibit 349 and 350. And do we have any other outstanding exhibits, Counsel?
I was wondering if they pat their back so hard they sometimes miss and slap themselves.
With like a big giant cock, just dick slap.
Wobbly.
Exactly. Flaccid, messy, icky cock.
Make sure that
second-hand bought.
But if the court allows us that privilege, then at this point rests.
Whoa!
Any objection? State has rested. No objection to the exhibits. The defense, prior to making argument, also has several exhibits we'd like to move in.
All right.
Would be defense exhibit.
Was that all the redirect? Oh.
We are getting ready for the defense's case in chief.
And
yesterday afternoon was so mind-numbingly boring.
Photos,
yeah.
And it was only spiced up a bit when the defense started to ask him questions. And why didn't you do this? I don't know. Why didn't you do that? I don't know.
57 through 60, 62 through 72, 74 to 76, 106 to 108.
2,000 pieces of evidence, and all I got was this crappy T-shirt.
129, 131, 133 through 136, 140 through 141, 143, and 144.
Also to chat
145
Wintersteel.
through
I am trying to
162.
make longer videos.
177.
I have one coming up where I do a mock defense
229.
closing of this trial, as I did
And
with
then I had noted
Murdoch
when
trial.
I
And that would be
received an
about a
exhibit
half-hour
list
video, I think.
that defense exhibits 248, 250, 252, and 253 had not been marked as received. However, those were the documents that Attorney Birdsall had used on his
Is this enough
cross-examination
coffee?
on Washington, and he had moved them in and they were accepted.
Yee.
So I just want the record to reflect that those had been previously received. I also have notes that Exhibit 262 and 319 were supposed to be received as well, but those were not marked. So I'd be asking that those markings be made and then the exhibits I had mentioned be admitted.
You said some of them had not been numbered?
No, they had been numbered. So defense exhibits 252, 253, 250, and 248, those had been already received.
Right, that I heard.
But it wasn't marked. Like
it wasn't marked that they had been received.
Correct.
Okay, I thought you meant they hadn't been numbered.
Sorry for the confusion.
Okay, not a problem. Any objection to receipt of the foregoing?
So, Council,
Oh, come on. Be rude in chat. Just don't be rude to my guest.
No. No.
I might come over there and say hi.
Redbreast 12 is the shiz.
Approached witnesses. We did not have the
You're rude to me in the chat. I will come over and say hi.
Sure the court had them. Were you moving those into evidence as well, or not those?
No, not those.
Okay. All right. So upon the assurances of the defense that the two exhibits I recall that were not allowed to be presented, Judge, were not. Yep, that's what I meant. Upon their representations that those are not included in their list, I have no objection.
All right, received.
And then Attorney Aubert will be making argument.
All right.
Reserve. You may reserve. Till a later point in the morning. Pardon me?
We have a motion outside the presence of
the typical
the state's case.
Yep.
Post-resting motion.
Okay, so what happens is that the state has now rested. The state has now rested, and it's time for the defense to take over. So what happens is the ritual of them asking for
Judge.
a directed verdict or a
Thank
a
you. The
verdict,
defense will call its
notwithstanding
first
evidence,
witness,
whatever you want to call it.
Julianne Avila.
They make their evidence saying the state has not proved in any way, shape, or form enough that the defendant was guilty of this crime, so therefore you must dismiss it. It's like the summary judgment or the whatever you want to call it in your state. It's basically the state has not proved their case at all, so therefore you must
swear the testimony you're about to give in this matter will be the truth, the whole truth.
It never happened.
And nothing but the
has
truth.
to make it. They'll do that when the jury's not ready. But now, for now, the defense is starting their case in chief.
Good morning. Could you please state and spell your name for the record? Oh, do you want to check see if the mic's on?
He doesn't even know her own damn name. We're up to a great start.
There you go.
That's much more appropriate for the day.
My name is Julianne Avila, JULIEANNE AVILA.
And how are you currently employed?
I'm a crime scene response specialist with the Wisconsin State Crime Lab out of Milwaukee.
And can you explain to the jury what that occupation entails?
So we respond to homicides, other investigations for maybe smaller departments that need help, officer-involved shootings, or any other major event that a submitter or an agency in Wisconsin may need help with.
And what kind of qualifications do you need for your job?
There are 4 of us who are full-time in crime scene response, and then we have a program chief. So for the crime lab, what we did was we have forensic scientists who had a major discipline. Some of us DNA, firearms,
I'll give you
latent
major
prints.
discipline, girl.
And then what we do is we go through training to learn how to approach a crime scene, how to respond, how to go through it, how to look for evidence that may be appropriate for the scene that we're called to. how to do proper collection techniques, documentation with photographs and video, and then eventually write a report. And so we bring our bench knowledge to the scene as forensic scientists to kind of try to get the best evidence that we can.
And how long have you been working as a crime scene response specialist?
So I've been a crime scene response specialist since January of 2020, but I've been involved with the crime scene response team since 2015.
No, that's not my type.
And prior to 2015, were you still working in the field?
Yes.
And what
she's a
type
field-
of education background do you have that assists you in your position?
If you're
So
tired
my
of working in the
degrees
field,
are in criminal
Niklas Starow,
justice
union
and
rep
a minor
labor
in
lawyer, can help
biology,
you
and I
out.
have a master's degree in forensic science. And then we had our other specialized training within the
Get you into the house.
laboratory to become crime scene response specialists with the training director at the laboratory.
And so you had noted that you had been working in crime scene response since 2015. Was that with the Wisconsin State Crime Lab or was that elsewhere?
That was with the Wisconsin State Crime Lab.
So
It's
since
Pat from
2015,
Saturday
you've
Night
been
Live.
employed with the Wisconsin State Crime Lab.
I've actually been with the crime lab since 2002. I was a latent print and footwear examiner.
So just focusing on your work as a crime scene response analyst, do you have to prepare reports for the things you do? Is that a normal duty in your job?
Yes, it is.
And can you explain that for the jury?
So the reports we generate explain who called us, who responded to the scene, what their duties were at the scene, what we did, what we eventually collected that may have been of importance. And then we also, before we leave a scene, we give over all the evidence that we've collected. So we may also make mention of what was given to the officers at the scene. And then we tell them, you know, that how many photos have been taken, where they can get those, and just kind of the overall documentation of what we did at the scene.
And during your time span of employment, approximately how many of these reports have you written?
Oh, I'd say probably maybe 75 to 100.
And I want to direct your attention to 2020. Do you remember doing work on a case regarding Zachariah Anderson?
Yes.
I'm going to show you what's previously marked as State's Exhibit 43. Judge, may I approach the witness?
Go ahead.
And while she's approaching, I think you all need to know who this witness is. This witness comes all the way from Saturday Night Live. It's Pat.
A lot of people ask, who's he or she? A ma'am or sir, accept him or her, for whatever it might be. It's time for androgyny. Here comes Pat.
So that's who our witness is today. Our witness is Pat, all the way from Saturday Night Live. A him or a her, a ma'am or a sir, it's Pat.
Lisa Treffinger's initials on it, as she was the peer reviewer of this case, with our laboratory case number on it and our seal on it.
And the case number correlates to maybe perhaps any and all work that the crime lab had done as it relates to the investigation.
Yes.
And what is that case number?
R20-1497.
And looking through the report and the date on that is September 3rd, 2020?
Correct.
Looking through the report, is it a accurate depiction of the report you prepared without any modifications?
Yes, it appears it is.
Judge, I'd like to admit State's Exhibit 43 and published to jury.
Is there objection?
Publishing the report? To the, like,
Just
hand
gonna,
it to 'em?
no, I'm just gonna put it on the thing.
Sure.
Go ahead.
She'll lick your
Okay,
envelopes
so
real good.
while this is up, if you could explain to the jury what this report is about.
So we received a Dodge Caravan into the laboratory that I was to look for any kind of possible blood evidence in the van. So I'm just explaining that both myself and Lisa Treffinger actually looked at the van. I took the photographs of the van. And then I talk about some testing that I did on stains that I observed in the van and the condition of the van, and eventually what it was that I collected out of the van.
Okay, and so item A is the van.
Correct.
I love you, chat. You guys are so fucking awesome. Oh, my sides hurt from you, chat. Oh, God.
Yeah. So the defense witness here is one of the people who actually were at the crime scene.
Yeah.
Yeah.
With the police.
Yeah, this is interesting. This is really interesting. How long did you work there? Well, up until an hour ago.
Yeah. I'm now fired because I'm testifying. Oh, my God. She hasn't moved. Move, blink, do something. There you go. She blinked. Oh, my God. My sides hurt from laughing. All right, we've got a few super chats we can burn through here while this shitstorm is going on. Legal Vice says, you must watch Cross by Defense and the investigators in the ice cream trial. We're going to be watching the ice cream trial after this one. We'll start late, but we'll go through the ice cream trial. Don't worry. Oh, I think I made a mistake.
Okay, and can you... What does this chart depict generally?
For the record, can we just say what
Sure, sorry.
If you're a Doctor Who fan, that's a Cyberman.
I created this chart just for my own personal notes, just to see where I tested stains in the van. I did not collect these stains, but I just wanted to make note of where I had done some testing. I noted where there was carpet missing from the van, and that's generally what this is, just for my notes.
And so wherever, let's start with the steering wheel. You had made a note for the steering wheel. What did that note indicate, if you remember?
There was a stain, a darker stain on the steering wheel that I observed, and that was just something that I tested.
And then if maybe you could just walk through each of the items that you noted and what you did.
Sure. So they don't have specific, some of them have numbers of kind of just what areas I tested. What I did was I used something called phenolphthalein, which is a presumptive test for blood. It's not a determining factor. It just is. It could possibly be. And so I tested the steering wheel. I tested the running board along the side of the driver's side of the vehicle. There was an area behind the front passenger seat, the seat belt, the carpet, and then the seats were all missing out of the van. So I tested a few areas of the carpet. I also tested it, if you know, like sometimes in the back of those vans, they have like cup holders where the seats would be. There were some reddish stains there that I tested. I tested areas on the metal parts, which is the bottom part that had no carpet. I tested along there with phenolphthalein, and they were all negative.
And when you say they were all negative, what does that mean?
There was no indication of blood using phenolphthalein as a presumptive test.
It means they're like,
Did
just
you
like
do
so
any
bummer,
other
dude.
tests?
They're like totally negative, man.
Strike that. There are other types of tests that can be employed to determine the presence of. Are there any tests that can be employed to determine the presence of blood?
Yes, so usually when we start out looking for blood, we're using basically just a high intensity flashlight, looking for any signs that appear to be reddish brown stains, as blood usually appears to look. After that, if something that you can't see with your eye, we might employ luminol, which you may have seen on TV. If you spray it in the dark, instead of giving a color change, it gives a change of light. It emits like a light. So once I was done testing with phenolphthalein, I used luminol and sprayed the van with that. And I saw one area that had a little bit of a glow, and I collected that stain.
And that stain, though, wasn't further tested.
I believe it was tested, but that would have been by the DNA unit. I didn't test it with any kind of presumptive test.
Was that A2?
Yes.
Okay. That wasn't A1.
Correct.
And can you explain to the jury if luminol reacts to any other substances or things other than blood?
It does. It's just a presumptive test, like phenolphthalein. It'll react to rust, bleach, and some other kind of cleaning products.
So it does react to bleach?
It can react to bleach, yes.
You had noted that there were some bleach stains in the vehicle. Or did you?
I did. They appeared to have the consistency of what bleach might look like.
When you did the luminol testing, did it react to those areas?
No.
And then you had noted that another thing that luminol can react to is rust. Did you observe any areas of rust in and around the vehicle?
Yes, the car did have rust.
What was your overall impression of the state of the vehicle?
The vehicle was had a significant amount of wear and tear to it. As I said, the carpet was missing. The carpet was dirty. There was a lot of clutter in it.
Sounds like my house.
And was it very dirty on the inside?
It was.
You had also taken some pictures.
Yes.
I'm going to go through them. It's a packet of pictures that were taken, marked as Defense Exhibit 352. Show you the first picture in that packet. It looks like a big dark screen, but can you explain perhaps what this photo was?
I don't remember what that.
Do you take photos when you're doing the luminol processing?
I do. And usually, usually what we do is luminol, because it has to be taken in the dark. Sometimes your exposures will be a little too dark.
Just like a good dick. It has to be taken in the dark.
It has to be like sometimes maybe a minute or a minute and a half exposure.
Printer
to try
out
to
of
capture
black.
it. And because the luminol was so faint, it doesn't really show up very well on this photograph.
Okay. The next picture.
I believe that is the area behind the driver's seat in the back. So in the back area where there would possibly be bench seats, there were some compartments back there and cup holders. Okay. These are just the items that were inside.
And was this one, we can see a reddish stain in this photo?
Yep.
Was that one of the stains that you tested?
I don't know for sure. I had marked them with like Post-it notes and stuff, so I'm not sure if that was one of the ones I tested or not.
Okay, I'm going to skip forward and then we'll go back to this photo. I might have to hand it to you just because of how.
Yeah.
Make it bright. operator.
Okay. Okay.
It's terrible.
Yep.
Okay. So now looking back at this previous photo,
Yes.
does that help?
Yes.
Okay. So was an area that was tested
Yes, it was.
and what came back negative?
Correct.
Mm-hmm.
And why did you want to test these stains?
Well, because of the color, of the appearance of them being a reddish brown stain, I was testing whatever I saw that could possibly be blood.
This photo area.
So this is a mid-range photo of the footwell of the driver compartment.
And did you observe anything of interest in that area?
No.
And did that area appear to have been cleaned?
Cleaned? No.
No, it's just never been cleaned. He's a filthy pig.
So this is the step area going into the cargo area or the passenger area behind the driver's seat.
Okay, and so this is the step threshold area that you tested?
Yes.
Okay. And I'll show you another picture of that. Is this just a close-up?
Yes.
And why did you test that area?
Again, there was a reddish stain there that I was interested in.
Because it possibly could have been
He likes
blood.
stains.
Yes.
And what was the result of that specific test?
It was negative.
She's so negative, man. Like, don't be so negative, dude.
That voice doesn't really fit with the.
This is the back area, the very back area of the van by the lift, back tailgate of the van. This is the metal part. You can kind of see a little bit of the carpet in the upper right-hand corner. And so
It's
this is
metal,
just bare
dude.
metal.
And the bare metal, was there a lot of dirt and debris on top of it?
It was dusty. It was kind of dirty.
It was dusty?
Yeah.
Okay. And there's also arrows in this photo?
Yes.
And are those arrows depicting areas that you tested in that area?
Somebody block Space Cadet.
And,
Jeff is not a rainbow guy.
the
Block
test
him.
for
Block him.
presence of
Just
blood?
kidding. Don't
Yes.
block.
And what were the results of those tests?
They were all negative.
Oh God, my face hurts from laughing so much. Oh my God.
What is this besides the obvious?
The steering wheel in the van, I have an arrow pointing to what looked like a reddish brown stain on the wheel.
And again, why did you want to test that stain?
Because of the appearance, I wanted to test it with phenolphthalein,
And the appearance of it,
being like a reddish brown stain,
okay. And the result of that test?
was negative.
Do you remember this?
I do.
This is the stain on plastic. This is the stain.
I believe this is the stain on the headliner above the cargo door area. It would have been on the driver's side. So as you lift the door, it would have been right up here at the top.
Okay. And that was tested?
It was.
And that was negative?
Yes.
There's this picture. Is there a reason you took this?
Just documenting the overall condition of the van and what was inside.
Okay. So in this case, the clutter.
Yes.
Clutter.
He managed to clean up right that spot, but not the rest of the van.
In this picture, was there any significance or just another overall?
Again, just documenting the overall condition of the van.
Okay, and in this picture, I'm gonna point to it on here, we see this container. Were you able to determine what that container was?
I don't remember offhand what that is.
Do you remember finding any sort of cleaning wipes or any wipes in the van?
I think there were, and that could be it. There were bleach wipes, perhaps.
Bleach wipes. Those are some awesome things, but they can't clean up a murder scene.
Judge, I'd like to move into evidence defense exhibit 352.
No objection?
No objection.
Received.
I have no further questions for this witness.
Go away, Pat. We don't need you anymore. A him or a her, a ma'am or a sir. It's Pat. Steve Martin had a love child. Anyway, what were you going to say, Nicholas?
Okay, so we talked, I think, about A2, Ms. Avila. We haven't talked
area
about
rug. If he transported stuff all the time, well, of course there could have been a leaking garbage bags, but from a construction site, like oil and stuff, and that you might want to cut out. Could have happened anywhere by anyone, and I'm not too keen in believing the daughter in that. Of course, the carpet was there on the 15th.
Well, we already had a witness say the carpet was not there. It's been gone the entire time. We've had a witness say that.
What day you and Ms. Treffinger did this process with the van? It appears to be prior to June or prior to late June at least. Do you remember when this was?
I don't remember the specific date, but I believe it was in May.
So if I indicated to you the photograph is dated 5/21, is that an excellent way to figure out when you did this?
Yes.
And so if you look up at the exhibit, does it have a time and date of the photograph? Yeah. So are these the photographs? Is your photography in this? If it says it started on 5/21, does that refresh your memory about when this happened?
Yes.
Okay, so just for purposes then of the record, when do you believe, based on your memory being refreshed, that these photographs and this testing is completed or done?
I took these photographs on 5/21, it appears.
Okay, of 2020.
Yes.
So you were asked briefly about the condition of the back of the van. Does this accurately reflect what you saw on May 21st?
Yes.
So when you saw it, the items that would normally anchor in the carpet or be anchored in by the carpet were situated off as they are in this, or have you manipulated that in some way at this point?
I pulled those off myself.
You did? Okay.
Yes.
So previously,
I pull myself off every morning. How about you, Nicholas?
If the carpet was still remaining. And you looked at a number of items where there was a red brownish thing in appearance, and you felt like you needed to do what you call
I don't want a step counter.
A preliminary test?
Presumptive.
Presumptive test, okay.
Were you jogging this morning?
At a number of locations on this vehicle, correct?
Yeah, that's correct.
And that includes on A2 that was brought up to you that was a area on the lower plastic molding in the rear cargo area. Is that correct?
Luminol will be a presumptive, yes.
Okay. So could you smell the bleach when you reviewed this particular vehicle? Do you remember?
I don't remember smelling bleach, no.
Could you see some clear stains, some of which are depicted on this?
Yes.
Did they appear to be consistent with bleach stains based on your observations?
They did.
So if bleach sometimes reacts with luminol, and if you're seeing a bleach stain, why doesn't the luminol do anything in this case if you know?
I don't know why it didn't react.
Okay. But you maintain that your physical observation is that appeared to be bleach stains?
Yes.
All right. Does luminol always react to bleach, or is that something where it is not always happening?
I would say it probably doesn't always happen.
Okay. So for you, it is an indicator, but it is not definitive in your experience.
Correct.
So how many times have you, during your employment, been an individual who was observing stains and having to make at least the most preliminary thought process about whether something is blood?
How many times?
Yeah, how many times do you think you've done this on behalf of the state crime lab?
Well over 100 times.
And in that time period, then part of that is because you're trying to figure out, is this going to be tested further, DNA unit, et cetera, correct?
Correct.
Okay. So when you came across A1, is A1 depicted on the exhibit that's up right now?
A1 is a great steak sauce.
If the judge gave you a pointer, would you be able... Remember those pointers from the old days?
Yes.
If he gave you one of those old traditional pointers, could you point out where A1 is on this particular exhibit?
Sure.
No.
The chat is great.
Okay, so you can go back. Thank you. So that you're at a microphone.
Thank you.
So are you the one who placed the sticker on A1 then?
Yes.
So this would be another one of those things that needed consideration for yourself and for Ms. Treffinger, correct?
Correct.
And this was a team approach. You and Ms. Treffinger were trying to consult at times where either of you felt the other's expertise would be helpful?
Yes.
So as to this A1,
nice, super unknown. Weebles wobble, but they don't fall down.
About whether any of the presumptive testing should be utilized on A1.
Yes, we did.
Okay, and why would you need to do that? If the other places you put little tabs were either sprayed or had a presumptive
Gavin,
test
you
applied,
are the
why
man.
would this one be one where you need to
Absolutely.
This
I'll
was
be right
a
back. Hang on.
very small stain. As Lisa and I were standing at the back of that van, I was on the passenger side, she was on the driver's side. We were looking in, and we have a height difference. And as I looked, I could see on that molding just this very, very small stain. And as we talked about it, we decided that it was best to just collect the stain so we had all of it, as opposed to trying to take a little bit of it for a presumptive test. It was just very small.
You didn't want to compromise your ability to have the whole amount there to be sure you had the most accurate ability to test.
Correct.
So did you have an opinion, seeing that item at that location, about whether it appeared to you to be blood?
I did think it was possible that it was blood, yes.
And then, and what did you base that on?
Just my past experience as a crime scene person and what I've seen with blood over the years of working crime scenes.
She's seen a lot of blood.
So I guess I need to ask you, as to the other stains that you saw, or the other spots you saw,
she's seen lots of
the
stains.
others appear to you to also be blood, or was this the one that stood out to you?
I thought the others possibly could be because they had a dark reddish color, but this one did stand out to me.
Okay. And what about it stood out to you? So why based on your experience, did you say, you know what, these others might be blood, but this one stands out?
Just the appearance of it, there was a little bit more, if I remember right, a little bit more to it. It was a little thicker, but it was so small.
That's what she said.
Had the appearance of just a spot of blood.
So let me just show you a close-up of this same picture, if I can.
I wish I smoked indoors.
And I'm going to bring this even closer if we can magnify this a bit.
Well, like my friend in Finland says, it's like illegal to smoke in your own home. Is it the same in Sweden?
Discussing?
Yes.
Okay.
No.
Okay.
If you're a renter, maybe. But
having been
not
a
if you're
crime
at home.
scene analyst,
Then
you said you've done
anyone
that.
telling me I can't smoke around my house, get off my
At that
lawn.
point, right? Are you still doing it now?
And that's
So you have
Mr.
an
Tractor.
3 years of experience at this since then, correct?
Correct.
Do you have an opinion as to whether the characteristics of what we see on the screen is consistent with items that have been transferred to that location as opposed to have fallen or splashed or something else at that location?
When we talk about transfer stains, we talk about something that may have either been on your hand and you touch an item and it's left behind, Or if blood is already on something and you put your hand through it, that's a wipe. The other one would be called a swipe. To me, this just looks like a very small speck of possible blood that was just possibly came off of something. It just got just a little bit of a drip or a splash, but it's not what I would call a transfer stain.
So in your experience, professional experience, it's not consistent with a transfer, with somebody deliberately applying.
It does not appear to be, at least in that fashion.
No. The last thing Junior did while exiting.
Nothing else.
Nothing else.
Can you please take down that? Yep. Apologies. So the stage is focused on A1, but like you said, there were.
This is a defense witness, Jonathan. Jonathan is asked, is this defense or another state? This is the defense.
Yes.
Defense has started their case.
And there were other stains that had a similar appearance as well.
Yes.
A similar appearance as item A1.
Right, with the reddish brown stain, yes.
No further questions.
Nothing else.
Hey, it's St. Patrick's Day. I'm going all green, man. Got the hat is from the Aran sweater market in Ireland. The sweater is from the Aran sweater market. The pipe is from Germany. From England. I got a watch from Ireland, a green watch from Ireland. We've got a green shirt from my buddy Frost Pipes in Finland, who is my Finnish pipe maker friend, Miko. We're all green today because it's Ireland Day. It's St. Patrick's Day. And 1/4 of my family are Finlays and Callahans. So fuck all y'all.
Yeah. St. Patrick's Day, the main reason why so many Irish babies are born in January with fathers uncertain.
Fathers uncertain. Okay, and on that note, we'll catch up on some super chats. The state has about much evidence of murder as the Irish had potatoes in the 1800s.
You saw us where the testimony you're about to give in this matter.
Okay, if you know, you know. If you don't know, that was like the Irish potato famine, so therefore the state had no evidence. Oh, and totally not a Russian.
Good morning.
Grifting
Can
pots
you
of
please
gold.
state and spell your name for the record?
Nathan Hensley, Nathanhensley.
Hensley.
And Mr. Hensley, are you currently employed?
Yes, I am.
What is it that you do?
I work in concrete. I'm a concrete finisher.
Very nice. I'm going to just jump right into it. Do you remember talking to law enforcement back in May of 2020?
I do remember, yes.
During that time, where were you residing?
I lived in Wood Creek Apartments.
Do you remember the address?
3709 15th Street, apartment 1A.
Okay, and you said apartment 1A. If you can just explain to the jury kind of the layout of that apartment building.
If you were to walk in the front, it would be the back right corner.
Okay, so did you know where apartment 1B was located?
I believe the front right corner.
So would have been the unit right next to yours.
Yes.
And look, thinking back to, I know it's a long time ago, but do you remember on May 19th, 2020, speaking with a detective?
I remember one came to our door, yes.
And do you remember being asked whether you were at home on May 17th, 2020?
I like that. That's funny. That's actually really funny.
I don't remember.
Okay. Do you remember providing a written statement?
A written statement?
Yeah.
No, I don't remember that either.
If I was to show you something, would that help refresh your recollection?
Possibly, yeah.
I'm good.
All right. Well, this. What?
The contents of it, do you remember saying that?
Yes, possibly. Yeah.
And was that, so now that you've reviewed that, do you remember what you told law enforcement about your observations on May 17th, 2020?
I believe I told him I didn't hear anything or see anything.
And was that in regards to the time frame that the detectives were interested in?
Yeah,
And you were home at that time?
I believe so, yes.
And you're saying during that time, so evening hours of May 17th, 2020, you didn't see or hear anything?
Not that I am aware of or remember.
I have nothing further for Mr. Hensley.
I have nothing further for him either. Be gone. And while he's being gone, let's try to catch up on some of these super chats here. Oh shit, he's gonna come and ruin it all. Squizgar says, I feel about this case like I did about Murdoch. Do I think he did it? Probably. He has the state proving that no. I don't think Zach did it. I don't think Zach had anything to do with it.
You know, or I'm not even sure he's dead.
Yeah. Stingy, haven't seen they physically crossed paths ever. Other than like the mild stalking, yeah, I agree.
So it's not Exhibit 1, it's Exhibit 353.
I demand Jeff be drunk on all trial days.
Can you take a look at that? Exhibit 353. What I want you to hone in on is the signature and tell me, does it look like that's your signature?
That is my signature.
Okay. Now, is the writing
That's
yours?
a Sabaton song.
Or does he fill that out for you?
Swedish pagans.
When you signed it, you were saying, best I know, it's accurate, correct?
Yeah.
Okay. So let's first talk about the date that you gave that statement. I assume that the statement you signed was at the same time the cop talked to you. There weren't two different visits, were there?
Not that I believe, no.
So you believe it was just one time you saw the police?
Yes.
Did they come to your place, if you remember?
Yeah, I'm pretty sure they came to my door.
Okay. So if I'm correct, it says it's May 25th, right? Is that the date that's on the statement down by where you signed it?
Oh, yes. Yes, it is.
So that would be the date that you talked to the police, right?
Mm-hmm.
Yes? You got to say yes or no.
Yes, I'm
okay.
sorry.
And they're
They
asking
waited a week to talk to the neighbors.
May 17th. Do you see that?
Yes.
So they're asking you about something that happened 8 days earlier. Is that true?
Yes.
So my guess is that you weren't keeping a diary or keeping track of exactly what you were doing on any given day 8 days earlier. Is that accurate?
Yes.
Okay. Now, it does say it was a Sunday. That helps remind you, okay, so where would I have been on a Sunday evening?
In church,
Correct.
Obviously,
Yes.
because that's where all the Lord's
at that time,
disciples
were you
go.
working on Sundays?
No.
So that'd be a day off?
Yes.
Okay. And so it says 200 hours, right? It's kind of military time. Does it say
8
20,
p.m.
2000?
Yes.
That's 8 p.m.
So they were asking you about 8 p.m. Is that how you took that?
Yes.
So nobody asked you about what happened at 9:30 p.m.?
No, not that I
The cops show up a week later and asks about the wrong time.
So if something happened an hour and a half or 2 hours later, that you're not talking about that in this particular statement?
No.
Okay. So I guess I'll ask, did you hear anything later in the night either that you remember?
I don't remember.
You don't remember. Fair. So were you living with somebody back in Wood Creek there?
Yes, my girlfriend.
Your girlfriend. Okay. So tell me what a Sunday night would have looked like. TV, music, computers. Were you guys gamers? What do you think? What would be your best help for us on what you would have been doing at 10 p.m. on a Sunday.
Go into details, please.
Either TV or movie or sleeping. Yeah.
All right. Sleeping was in the picture even at 10?
Yes.
All right. If you were asleep, you wouldn't hear anything. That's fair? Or unless it could wake you up, but otherwise you wouldn't.
No, it wouldn't wake me up. No.
What?
I'm a heavy sleeper. So,
Oh, you are?
Yeah.
I'm stoned out.
I think I'm going to end with that. Thanks very much.
Nothing further.
I wish she had pointed that out. The cops didn't show up until a week later and asked about the wrong time.
Yeah, you can hand it to me. Thank you. I guess we'll keep it as part of the record.
The defense will call Jennifer Ziegler to the stand.
Let's go, Ziegler. All right, I'm going to take, we got like a bunch of super chats here to clear through. Squizgar 2322 took me a while to pronounce that. Calling a witness like this by the defense is brilliant because the state is less likely to really want to tear into them. Yeah, because they were part of the investigation. So good for them. The state doesn't call them, the defense will. The Contralarian. Hey, I'm not too drunk to pronounce that. What is the current trend with prosecutors using lack of cell phone activity as evidence a defense is committing a crime at that time? Seems very weak. Yeah, I mean, that's the thing. It's like technology is like, ooh, this is the new thing that your cell phone tells you where everything is. Forget whether you left it alone or you left it at home or whatever. You know.
Please be seated.
Good morning, Miss. Is it Ziegler?
Ziegler, yes.
Ziegler. Can you please state and spell your name for Madam Court Reporter?
Yes. Jennifer Ziegler, Jennafer.
Jennifer, that's weird.
Gler.
And are you in a relationship or residing with an individual named Nathan Hensley?
Yes.
And for approximately how long have you resided with Mr. Hensley?
A little over 4 years.
So back in 2020, were you residing with him?
Yes.
And I'm going to give you a specific time frame. In May of 2020, do you remember where you were living?
Yes.
And where was that?
Wood Creek Apartments.
And do you remember your specific address?
I think it was 3709.
Smash or pass. 1 for smash, 2 for pass. I'd smash.
If I said 15th Street.
She gets my
right?
one.
Yes.
I'd smash her.
And do you remember your apartment number?
1A, I believe.
And so in Wood Creek Apartments, while you were living
smash
there,
or pass.
did you
One
know
smash,
an individual
2 pass.
named Mr. Gutierrez?
No, not personally. I knew him after everything kind of happened. I guess I heard of him.
Okay. And do you know where apartment 1B was located in relation to your apartment?
Yes.
And where was that?
So it would be right next to us, basically. Yeah, to our left.
She's a definite smash, according to the chat.
So I want to jump back to May of 2020. May 17th of 2020. It was a Sunday. Do you have a recollection now? I know it was a while ago about what you were doing on that date.
If it was a Sunday, I probably would have just been at home, or maybe I was with my parents away at their house. So it'd be either or.
Okay. Do you remember speaking with detectives in this case?
Yes.
And you spoke with detectives on 2 separate occasions.
Greg Hansen, obviously gay.
Was one
sorry, Greg.
The first time that you spoke to a detective, was that because they came to your house or your apartment, or did you go to the police department? Do you remember where that conversation happened?
Yes, they came to my apartment.
I like long neck and big noses.
that
I'm weird.
The
That's my
day where there
fetish.
was a lot of law enforcement there?
Broad shoulders.
And you remember seeing all of that?
Yes, I do. Yeah.
And do you remember what the detective asked you?
I think he kind of asked me like if I seen or heard anything.
And would that have been for that Sunday, May 17th?
Yes.
And what did you tell the detective?
I'm pretty sure I told the detective that I did not hear or see anything.
And was that accurate?
Yes. Yeah.
And So were you then home on May 17th, 2020?
Yes.
And for that entire evening?
Yes, I would have been, yeah.
And that entire time, you didn't hear anything?
No.
Or see
There's
anything?
always blowing cock.
And now, thinking back to when you were living in Wood Creek Apartments, if there was a very loud noise or someone screaming or yelling, would you think you'd be able to hear it?
Objection seems like it would call for speculation.
Kind of sounds that way.
From when she lived there, her own observations, if she could hear things that were loud.
Everyone's.
If you can't hear, then you don't know that you're not hearing.
Okay.
If you can't hear, you don't know that you're not hearing. Ooh, the judge dropping logic bombs.
Have you heard people arguing or screaming before in Wood Creek Apartments?
Arguing, screaming, no. I heard footsteps. I hear footsteps and stuff like that, like doors shutting and stuff like that, yeah.
And so thinking back to May 19th when you were giving this statement, if you even heard things like that, you would have told law enforcement?
Yes, yes.
And you didn't hear anything of that sort?
No.
And I have nothing further. Thank you.
Any redirect?
Ms. Ziegler, so you, Ms. Ziegler, you believe that at first somebody spoke to you while the cops were still around?
Yes.
So were you not working during the day?
I worked Monday, Wednesday, Friday. So Tuesday and Thursday I was off. So I'm assuming it was on one of those days.
She'd be DTF,
And so
clearly.
You were home when they came and asked?
Yes.
All right. And were they, to your mind, were they asking about something that had happened the night before, or did they, I'm talking about the first time they talked to you, or were they talking about a specific different day?
It was a different day. It wouldn't have been like that day.
Okay.
Yeah.
So so if the cops were still there and they were asking you, how do you have any idea how they would know which day to ask you about at that point?
I'm going to object. Calls for speculation.
Yeah.
She knows. If she
Yeah,
knows.
I don't know.
Okay. So, but then at some point you also were asked to give a written statement, correct? Yes? You
I
got to
think
say
so.
yes or no for the record. You can't just say.
Yes, sorry. Yes.
And at that time you were again asked, and they asked you about a specific day that time, didn't they?
Yes.
Okay. So I'm going to show you. First, I got to get it marked.
Yeah.
Well, you know, it's true. All right, let's see if we can get through one more super chat. Boomer Wow says maybe compress mic before it gets to StreamYard. Way too late,
The
bro.
first thing I want you to do is look at the bottom of this and just tell me, do you recognize your signature?
Flux.
Okay.
Jeff is so spicy today.
Yes.
So is that your signature?
Yes.
Okay. So when you signed that, were you trying to report everything you knew based on what people were asking?
Yes.
Okay. So is there a date by where your signature is that says when they were asking you about that? So you know what date they were
I like
asking?
those rat eyes. They're kind of sexy. Rat eyes.
In the area where your signature is.
Yes. I see a date right under.
And so what is that date?
5/25/2020.
Okay. And so, and then in terms of what time they were asking about, date and time, is that at the top of the document where it says on May 17th, 2020?
Yes.
So that'd be 8 days difference, right, in terms of this statement?
Yes.
Okay. And on Sundays, you didn't work?
Yes.
Okay. And were they asking you, based on the military time they wrote down, did it look like they were focusing on 8 p.m. on the evening of May 17th?
Yes.
Based on military time. It says 20, right?
Yes.
00, which would be 8 p.m.?
Yes.
Okay. So I want to actually ask you about a couple hours later on a Sunday, okay? And whether people maybe were headed for bed and things like that a little later. So by 10 p.m. on a Sunday, do you remember whether you guys would be in bed yet?
Yes. I go to bed early, so.
Good. Okay. And so if I told you it was at 10 p.m., would you expect to hear things out in the
I
hallway?
don't object to speculation.
Well, I didn't hear the whole question. It smells that way.
Well,
but you use the word expect, so
yeah.
you can put your question, but you're on borrowed time.
And the court has allowed me to pay up on those borrowing a couple of times. So my question is, if it was at 10 p.m. on this Sunday, what, if anything, can you tell us about how that would impact your ability to hear things in either the hall or the neighboring apartment?
Yes, because we sleep with a box fan, so we wouldn't be able to hear.
What?
Coming to end there, Judge.
I do have some redirect, Judge. Thank you. You talked to law enforcement twice.
Yes.
So the statement that Attorney Gravely was just going through with you, that would have been the second time you talked with law enforcement?
Yes.
And thinking back, if they were detectives asking you about that entire evening of May 17th, 2020.
Yes.
And if you were sleeping and you knew you were sleeping at that time, would you have told law enforcement that?
Yes. Yeah.
Nothing further.
That was pretty simple.
You're saying that if you went to bed sometime on the evening of May 17th, you would have told the officers I went to bed?
No, sorry, no.
Okay.
No.
Nothing else.
She's like hot. She's like
Very,
totally
very
my
limited.
type right there.
You told them you didn't see or hear anything.
Yes.
And it wasn't because you were sleeping. Let me rephrase that. If you
Michigan
had been
State.
sleeping, would you have told law enforcement I was sleeping, so would not have been able to hear or see anything?
I just told them I just didn't hear or see anything just because they just asked if I heard or saw anything that day.
And thinking now, can you remember if you were sleeping or not?
No, it was 3 years ago.
Okay.
But I would be sleeping because I go to bed at 9 p.m.
At 9 p.m.
Yes.
Oh, never mind.
And
She's
I've
not
been
my
going to
type.
bed at 9 p.m. because I wake up at 5.
Nothing further.
She might be Chandler's type. She's not my type. Anybody that goes to sleep at 9 p.m. can just like fuck right off. And speaking of Chandler, it's Chandler Remington.
Hey, good morning,
Hey.
good afternoon, good evening.
Chandler Remington.
Yes. Nice to see you, Jeff. You seem to be in a boisterous mood.
I am. It's St. Patrick's Day. All right, we have Aaron, Swedish pagans marching ashore, forged in Valhalla by the hammer of Thor.
Call Kim Lavora.
That's a Sabaton song, for anyone wondering.
Yes. Chaz Berglund, Legal Vices, sent a DM on Twitter. I did not get your DM on Twitter. Seeking a Scotch or bourbon recommendation. Bring on Mighty Meat. I did not get your recommendation, so sorry about that. YouTube. Team YouTube became a YouTube member. Thank you so much. Deeply, deeply appreciate that. We have to let's go to the bottom and then scroll right back up to the top. DUI guy Larry in the house. My two favorite boomers, Legal Vices, Niklas in one place. It is St. Patrick's Day. It is a $100 super chat. So we got to go with the we got to do a shot here.
I will join for one because I have to travel in the morning. But
Larry shot. Larry, I sent you a link. If you're bored and not doing anything, come on in and join the crew. And Jonathan says DUI is a low-key boomer. Well, thank you for talking to Larry with another $100 super chat. So you get a what is this called? A shot too. Thank you, Jonathan.
It's called a shot. Is that the peanut butter whiskey?
Nope, this is oh god, this is Bushmills. Irish
Oh, okay,
whiskey.
good. I was worried. I was a little concerned that. Did you try the peanut butter whiskey? Was it any good?
I did.
morning.
We'll talk about that in a break.
Can you please state and spell your name for the court reporter?
Sure, Kim, Kim, Lavora, Lavora.
And Miss Lavora, is there another first name that you also have?
Yes.
Could you please state and spell that also?
Sure, Eumdeun, Umdean.
Oh fuck! I can't figure that out.
Is it
I'm
okay
too
if I
drunk.
just refer to you as Miss
Yeah.
Lavora? Okay.
Whatever.
Miss Lavora, are you currently
No tag
employed?
for you.
Yes.
You're too
And
confusing.
what is it that you do?
I'm an accountant
Where?
at Wackernusen.
Okay. And how long have you been employed there?
It will be 10 months.
I'm not.
Nice.
I'm Gen
Okay.
X.
No, you're fine. I want to kind of jump back in time to May of 2020.
Sure.
And during that time frame and before, did you know an individual named Rosalio Gutierrez?
I only know him through text.
Can you explain
you're texting
how
him
you know
too?
him in as much detail as possible?
Oh, sure. I was on a Facebook dating site, and then he liked me, and we started conversating through text only. Had a few texts. I felt like I felt nervous. I never met him. We talked every day. We text every day. He told me personal things about him, his daughter, his business. Moving forward on to May, he told me that he was going to Menards and picking up his daughter, and then the following days when it happened.
So I wanted to go back a little bit. When did you first, if you remember, when did you first start talking to Mr. Gutierrez on Facebook?
He's a player, man. Gutierrez is talking to everybody. Her, his current girlfriend, Sadie, the court clerk
Maybe
from
February.
Milwaukee.
It was really short. It was only for a few months.
Ooh.
Yeah, he played the field a little.
And from the time that you started talking to him to about May, let's say 18th, 2020, what was the frequency of your communication?
Texting. We would text frequently every day. When I got off of work, I would give him a phone call. We would talk about an hour or two, and then I didn't talk to him for the rest of the night. And then it would continue the next day.
So not only just texting, but also phone calls.
Correct. He wanted me to meet up with him in Kenosha, and I said, no, not today. No, it's not today. I did. My gut told me no. So
She's
I
a
never met
cock
him.
blocker. Not today, not today, not today. Meet him or don't.
When you're
Shit or get off
talking
the
about
pot,
all this
chick.
talking and calling, what was the nature of the relationship? Was it just friendship, or was it more of a romantic relationship?
No, for me, it was just friendship. He wanted probably to take a step further, but I wasn't comfortable with that. So that was it. For me, it was strictly just friendship.
But you're saying for him,
yeah,
it seemed that he wanted more?
Of course he did. He's a man.
And jumping to May 17th, 2020, do you remember having a phone call with Mr. Gutierrez?
If that was a Sunday, yes.
It was a Sunday. I'm going to show you what's been marked as Defense Exhibit 75.
Yeah, seems like Sadie wasn't the only woman. She was the woman he managed to bang.
Chandler is like a distant number 3, it sounds like.
So it's just going to pop up on the screen.
Sadie's pissed right now.
But no, their relationship was special.
And DUI guy Larry says Niklas channel is almost at 1,000K. Everybody get down there to Niklas Starow of Union Labor, whatever the labor, what? Labor law lawyer? I'm drunk.
Union rep labor law.
Yeah, go to Niklas Starow and get him to 1,000K and get his 4,000 hours, get him monetized so he can start grifting the griftiness that is YouTube. And Larry, you've got the link in you've got the link in Twitter if you're like bored and want to join.
Kind of. It was night. I know it was night. It was dark out.
Okay. And that's your phone number?
Correct.
Mm-hmm. So that's 414-334-1158?
Correct.
Oh, sorry.
Oh, sorry.
Is that her current phone number?
That's her number, this date, and it
Good
says
luck.
That phone call was about 17 minutes. Is that how long you remembered it being?
Yeah, because he was saying he had to run errands, go to Menards, pick up his daughter. He was like, when I get home, I'll give you a call. And he never returned. He never called me back. And then when I called him, probably a couple hours later, the phone just kept ringing and ringing and ringing and ringing and ringing.
Banana phone, ring, 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 ring.
After the 17-minute conversation, you said he told you what he was going to be doing.
Oh my God, I remember that.
Yes.
And can you say what that was?
Oh, and hold on for a second. Objection, it's hearsay. What he told her on the phone.
Why would it not be?
Oh no, Brad,
It was
no.
just the impression on Miss Lavora about what she thought he was doing, not offering it for the truth of the matter asserted.
What difference does it make what she thought?
That's the defense's position. I have nothing further, Judge.
Do you have any other questions?
No, I'm objecting based on hearsay.
Well, I have to say the sound is so bad in here.
Yeah.
I thought she said that is the defense's position, nothing further, Judge, which I thought was the end of your examination.
Maybe it was.
Maybe you just didn't want to haggle with me.
Nothing further on our position on the objection.
Okay. Let's take a break. Please don't talk about the case during the break. Read, watch, or listen to any account. And 10 to 15 minutes.
Oh, it's a 10 or 15-minute break. That is awesome. Now I can relax for a bit. Let's just like chill the hell out here. It's 12:44 a.m. here in Korea, 11:44 a.m. in the Eastern Daylight Savings Time, and whatever the hell that is for the rest of the world, I don't know, because I'm liquored up because it's St. Patrick's Day. Oh, let me get rid of lawn cuck here. Lawn cuck.
I'm not.
No,
I'm not going to repeat that same joke from
yeah,
yesterday. That
don't
was so
even try.
dumb.
Yeah, that's bad. Yeah. Don't do it. All right, I got a couple of super chats to burn here through. Bear with me, folks. Jonathan, have you tried the peanut butter whiskey? I had. If you'll see, there is exactly like one shot missing from here. You will be my review test dummy. Go to Meme Copium and watch his stream, because I tested it live on Meme Copium stream. It's weird. This is Old Smoky Tennessee whiskey, peanut butter flavored whiskey. It's interesting. Like the first 5 seconds are really horrifically offensive. But after that, it just sort of tastes like warm melted peanut butter. It's weird. So it's like bad, but then it becomes good. And I don't know what I'm going to do with the rest of this bottle. It was just cheap, and it was in the convenience store next to my house when I went to buy some eggs to make a really good cocktail. So I bought it and I tried it on Meme Copium stream. So I don't know what I'm going to do with it, but it's weird. It's weird.
Yeah, I've tried it. It's I actually got like a little like mini, in a birthday gift basket years ago from an ex-boyfriend, and it was I would not recommend it. I did not like it.
Well, they have
Don't
like
send it to me.
the screwball whiskey that has the sheep on it. That peanut butter, I have no idea what that tastes like. This is Old Smoky Tennessee whiskey, peanut butter whiskey. That's the only thing I can attest to as far as peanut butter flavored shit goes. But it's weirdly like bad but good at the same time. It's a dialectic. I can't process it. Nick Naylor, do not get me started on them necks, boy. Needs me a girl that I can get the leaves from the top branches. Know what I'm saying? Yeah, the giraffe chicks. Yeah, I like the giraffe girls. Necks and noses are my weird fetish. I like necks. I like noses. That's me. Just, Now, Matt Madge has brought up an interesting point. Jeff, who's Patty? Look how you spelled it under legal advice. Yeah, on Twitter, I deeply, deeply, horrifically apologize to everyone in Ireland. I spelled it with 2 T's instead of D's. I deserve to be shot and burned at the stake as a witch. It is P-A-D-D-Y, not P-A-T-T-Y. I'm an asshole. I'm a freak. I'm a dick. I'm a jerk. I deserve to be beaten with a wet noodle until I scream to stop. St. Paddy's Day. It is St. Paddy's Day. P-A-D-D-Y. But just in case, just
Patrick, or however you spelled that, you definitely deserve to be canceled for that, Jeff. I don't know.
Always say St. Patrick's. Just say St. Patrick's Day to be sure. It is Patty. No. It is Paddy. St. Paddy's Day. I apologize. I'm a heathen. I'm a jerk. I'm a dick. I don't deserve to live. Mad Cow Mark. She's my type because any type is my type. Can't argue with that philosophy.
At least you can be honest about your standards.
And the DUI guy brings up a very, very important issue. Nicholas's channel is almost at 1K.
I have 848, so I need 152 to get to 1K, and then a lot of watch hours on that.
Get him up there to he needs the 1,000 subscribers. Then we need to get the view hours up to 4,000 so he can monetize this shit and grift like a grifty McGrifferson. Definitely get there. You demanded that he be brought back for this trial because he's ridiculously hilarious. As in, if you watch the beginning of this, the Vikings just popped into Ireland to say hello. Back in the 900s. Hello, rather than just rape and pillage everyone. But yeah, DUI guys, Nick's channel is almost at 1,000K. We need to get him to 1,000K. And me personally, where the hell am I sitting? Let me bring up on my phone. My goal is to get to 36,000. I am 230 subscribers away from 36,000 exactly.
Oh, that's close.
230 of you here, and we currently have 2,127 of you. Clearly 230 of you have not subscribed to me. So if you have not subscribed, I would be gratefully indebted to you forever and ever and ever if you would reach down there and smack that subscribe button, subscribe to me, and while you're at it, why not hit the like button? Just do your job. We got 2,104 people and 1,306 likes. 700 of you at least haven't hit that like button. We have our like and subscribe poll up here. The like and subscribe poll, how are we doing so far? We are 1 hour and 51 minutes into this. 12% of you said you hit the like and subscribe button to get me to 36,000 subs. Oh, come on. That's the whole purpose. That's the whole reason I'm doing this. I want to get to 36,000 by the end of today. Only 12% of you chose that. And 21% of you said I hit the like and subscribe button because you're mildly entertaining. I'll take that. 24% of you said I hit the like and I hit the subscribe button and the like button too because XOXO V Bear, Vice's Bear for that win. And finally, in the far distant lead with 42% of the vote, I hit the subscribe button and the like button too because this is an awesome channel. All right, we'll check back on that like and subscribe poll in about an hour. That's what we do. Chandler, good morning to you.
Good morning. I'm so sorry that I was late. I was listening, and I'm sorry I missed the "It's Pat" moment because that was hilarious, and I was laughing my ass off. It was really, really good. I love that you played like the whole intro. The resemblance is uncanny, I've got to say.
It was. And we'll see if I get copyright claimed here before this is over. Probably will, but what the hell? Yeah. What the hell? I don't care.
That's not fair use. It should be fair use.
I didn't talk or mad any comment. I just played it. So, if they copyright claim me, I literally have no defense against it. But
it was an analysis about the likeness, so it goes under analysis.
I think so.
Yeah.
That's a good point, Niklas.
Not legal advice.
But Saturday Night Live is like notorious copyright clucks.
Yeah.
Like they're chickens.
Copyright clucks.
They're like chickens. Yeah. So Chandler Remington, you are here this morning. It is early morning for you. Welcome.
I mean, it's not that early. It's what time is it? It's 8:52. So I've been up early.
8:52 is really early, especially on St. Patrick's Day.
Mm-hmm.
Oh, wait, what the hell did I do? Sorry.
You removed me. Why did you do that? That was so mean.
I know. I'll just do it again. Why not? There. Because I have the power. I have the power. And okay,
yes,
so if you're just joining us, what's happening is we're just doing a bunch of nonsense here. but there hasn't been much of a. The prosecution has rested their case. The prosecution is done. Now the defense has started their case in chief. They've brought like generic witness number 1, and she's testifying about all the stuff that happened at the crime scene to sort of basically say there's no blood evidence, there's no DNA, we didn't collect anything, we didn't do anything. That's how far we've gotten today. And when we come back from this break, we'll continue with the defense's case in chief to see what they're saying. But basically right now is that nothing much is happening. And I think we're at the point now. Like I said, I never do the guilt or innocence polls before the prosecution rests. But the prosecution, back up. That was the liquor talking. I never do it before the prosecution finishes their case in chief. The prosecution has finished their case in chief. So essentially what they've done is now the prosecution is saying we have presented every single piece of evidence we have to prove that Zachariah Anderson murdered someone, hid the body, as well as stalked the missing person and Sadie. That's what the prosecution is saying. They said we've presented every single piece of evidence we have to tie him to the crime of murder, hiding a corpse, and stalking 2 people.
Yeah, I've got to say
now the defense. The defense is doing this. So now I'm going to put up the poll. So Niklas, tell me your opinion of this case so far.
We are almost at 2 hours.
Almost.
Yeah. Well,
4 more minutes.
4 more minutes. First of all, I'm not even sure the guy is dead, because when I saw the crime scene photos, you don't see what the prosecution hinted at in their opening, this sea of blood everywhere, walls covered with blood spatter. There's driplets here and there, and there's a pool of blood on the floor, and a pool, some blood where he sat.
Yes.
But the prosecution haven't said, well, did it start off in the couch and ended on the floor, or did he got beaten down on the carpet and then sat up on the couch? Nothing of that makes any sense, and definitely not. I don't believe that even with that missing rug, I don't believe there is enough blood to suggest that the guy is definitely dead.
But do you think that's a problem? The state seems to have implied that there was so much blood he bled to death, where they didn't offer the fact that you can just be hit in the head with a baseball bat and die with literally no blood spilled. Do you think that's a problem the prosecution has created?
Yes. Well, they haven't presented much other than asking the jury to fill in the blanks. They said, there's blood here, there's blood here, there's blood everywhere. Please connect the dots for us. They haven't really presented that case. Yeah. And then you have that when the cops came to the scene, the blood was still wet, which I have a bit of a problem with, because yes, it takes some time. Don't ask me why. It takes some time for blood to completely go dry, but 2 days, that's a far fetch, and they haven't presented why. And that's why I hope that the defense will come with an expert who testifies to these differences. But then again, they don't have to prove anything. But then again, the prosecution haven't proved anything. It's weird. It's 1 minute until I can say unhump a cluster hump.
Cluster hump. Chandler, what do you think? You've watched this from day one. Where are you? There's the 4 charges: murder, hiding a corpse, stalking Sadie, and stalking the missing Gutierrez. Where are you on these charges?
Personally, if I were on that jury, I don't think that I could confidently say that any of these charges apply. There is a little bit of evidence that could imply stalking, but a lot of the evidence actually rests on the testimony of the teenage daughter who appears to have been heavily coached, who appears to have been heavily influenced by her mother, brainwashed, etc. And that kind of taints the evidence, in my opinion. So although I think that it's possible that he could have engaged in some stalking type behaviors, I see that a little bit less with her testimony, and I don't see a murder charge whatsoever. There's no evidence of his DNA at the crime scene whatsoever. I think it is impossible to commit a murder and not leave your DNA at the crime scene. When has that ever happened? I mean, somebody correct me if I'm wrong, but I don't think it's possible, and I don't have confidence that he had time to move the body, that he had the physical fortitude to move the body, that he would have been able to cut up the body or whatever he had to do with it in order to make it transportable. I don't even know if this guy's dead. Like Niklas says, I completely agree. There's no evidence that he's dead. So I'm not seeing these charges being substantiated. I would vote not guilty on all of them, personally.
Niklas, comments?
There's so much to suggest that he has disappeared. Besides that pool of that blood not being enough, that I checked the Wisconsin alimony site, how much he could have owed to all his baby mamas, and it is at least $500 a month.
Yes,
and that's not chump change, especially not if you're already in financial. Well, suggesting that he lived in a quite cheap area and stuff like that. And on top of that, he owed some suspicious figures money. One of them was on the stand and said he owed him a lot of money.
A lot, yeah.
Yeah.
He didn't say how much. He just said a lot.
Yeah. Now, I don't know how much is a lot for that guy, but I doubt it is, because the last witness from the prosecution said something about $60.
Yeah.
And that's not a lot of money, even if you're poor.
True.
You're true. Yeah.
But there was that one man, I believe it was Mr. Campbell, who mentioned that Rosalio owed him money very frequently. They worked together on contracting jobs. And prosecution tried to argue that the figure that was owed was not relevant because it was supposedly under $1,000. The problem that I find with that is that for some people, if you continuously owe somebody money, if you're constantly borrowing money for somebody, and there's animosity and contention over other potential issues having worked together, you don't need to kill somebody over a large amount of money. I mean, people kill people over a chicken sandwich. You know, you see headlines like that in Florida.
So why would it be you and I get along so awfully? Yeah, exactly.
I mean, people will kill people for nothing because they have anger issues, because they have a bad temper, because they have bad impulse control. Maybe with these guys that he owed money to repetitively over time and wouldn't pay back, it's possible that it was a sum that added up. It's possible that he was sick and tired of it. It's possible that he just had a bad temper and he didn't want this guy owing him money anymore. I don't know. Anything is possible. I don't see it. I just don't see the murder.
That's the problem. You say anything is possible, but the prosecution has to prove beyond a reasonable doubt that their theory of the murder is the only way this could have happened. If you can say, okay, it may have been this person, it may have been that person, it may have been the other person. If you can say that, that indicates a reasonable doubt and mandates a not guilty verdict by the jury. But that is from a legal analyst point of view. But from a regular schlub off the street, like my torts professor, Tommy Torts, we called him, he would always refer to the jury as the 12 ignorant slobs. And he would say, like, for 1/3 of the recovery, name that tort for the 12 ignorant slobs. So like the people that are on the jury, they're just the random, everyday, ordinary guys and gals.
Like me.
how are they seeing this, do you think? As the non-lawyer on the panel, Chandler, soon to be lawyer, like 3 or 4 years down the road, like what do you see? I mean, from just a layman's perspective, what do you see going on here?
Well, it's hard to say because I definitely have a pro-defense bias because I believe very strongly in due process. But
okay, let me pause you there. Don't lose your
Okay.
train of thought. Just
Okay.
ignore me and focus on your train of thought. That is the thing. That is what I always say. When you're going to these trials, you should have zero bias except for the bias that the defendant is innocent and the state has the burden of proving you wrong. The state has the burden of proving you wrong by bringing up his guilt beyond a reasonable doubt. If you have a reasonable doubt whatsoever, you must acquit. So, okay, continue. Sorry.
Yeah, please.
If Schroeder doesn't have anything important to say.
Not yet.
Well, okay, essentially, from where I sit, if the prosecution's theory is that Zachariah Anderson went to Rosalia Gutierrez's place, he was so jealous, he was so angry, he took a baseball bat, hit him over the head, rolled him up in a rug, put him in the back of his van, then disposed of his body later on. That's the theory that they're trying to sell. I don't think that they've sold it because every single witness they've put up on the stand has been sketchy as hell. They have been evasive. There are a lot of problems with the witnesses for the state. And if I were on the jury, I would be looking at these witnesses and I'd be going, something isn't right here. These people are being evasive. They're not totally telling the truth. They don't seem trustworthy to me. And it feels like there's a different story that makes more sense here. I don't know what it is. I can't explain it. I can't tell you what exactly happened. But looking at this man, when they read those texts between him and Sadie, what I saw was a man who was very hurt, who was in a lot of pain, a man who was trying to protect his children, definitely a man who, had a very toxic relationship with his ex. But I don't see him as a murderer. I don't think that that's what's going on here. And so if I'm on the jury, I'm looking at this and I'm going, I think there's a different story. And I don't think that the state's story makes as much sense as what might have happened.
I agree with that. And Schroeder is calling the jury, so let's burn through these super chats here. You can tell he knows their case is drowning by the way he comes at defense witnesses. Love that they ain't giving him much to work with on cross. Lol. Good. I agree with that there. Old Smoky salted watermelon whiskey is so good. Salted
I've heard. I think Emily D. Baker was drinking that on a stream once. She really liked it.
No. This peanut butter whiskey is enough from them. Old Smoky peanut butter whiskey is enough weirdness for me. Mix the peanut butter whiskey with grape juice. Oh, I'm not even going to try that. No.
That's offensive to whiskey. That
ain't going to happen.
Are you going to ban that person? Because I feel like they should be.
Yeah, Jeff, guess who was right? I have no idea what that means, Will Red, but yeah. Okay, fine.
I can eat just about anything, but those drink combinations.
Yeah.
Nah, I'm good.
And CHD says legal vices. I think the state proved that Junior had a really heavy flow that week and was out of Tampax, but that's about it. Ew. No. That's wrong. Official Rogue Ent says Sadie thought she was the only one. Yeah. She was mistaken. Wild Red. Yeah, Jeff, guess who was right? Again, I have no idea what that means. But again, I'll read it again because, hey, liquor. Here for the truth. I was too early. Now I'm so late. Did I miss much? Recaps, please. No time for recaps. Kelly R. Sadie, a smash, but no future. Right? I bet Sadie using sign language now. And Nick Campbell. Man was using Chat GPT to text all the girls, and we have Danny on direct.
Danny, hey,
I missed you,
Danny,
Dad.
my
How's it
girl.
going?
I'm so happy to see you.
Love you, Danny. You are the best.
You're the best. Happy St. Patty's Day, everybody.
Happy St. Patty's Day.
Why is my brightness all the way up? I'll adjust that, Jeff, while you keep reading super chats. Can you guys hear me?
I hear you.
I can hear you.
Oh, okay, good. It was just super silent after I was done, and I was like, wait. Excuse me. How is weather where you are, Chandler?
It's lovely. It's a little chilly, but it's kind of sunny today. How about you?
Good. Very good. Is it still raining? You're in California, aren't you?
Yeah, it's been raining on and off. It's been a very, very rainy season. It's supposed to rain again next week. I actually don't know if we're supposed to have rain today.
Let's bring up folks here.
Do we have more super chats?
No, we've got trial. Hang on.
Oh, we have
There we
trial.
go.
Okay.
Damn these trials interrupting a good conversation.
Seriously, like totally.
And you indicated that through May 17th of 2020, you guys were in communication daily, multiple times a day?
Correct.
And after your phone call with him on May 17th of 2020, did you ever hear from Mr. Gutierrez again?
After that phone call, no.
And after you didn't hear from him when he was supposed to call you later that night, did you then try to reach out to him multiple times to?
Correct, yes.
And were any of those ever answered?
No.
No.
Did his phone start going directly to voicemail?
It started ringing continuously, a couple times, and then it went dead. So.
And during your friendship with Mr. Gutierrez, was it unusual for him not to get back to you in a timely fashion, given how often you guys spoke?
Yeah, that was very strange.
And ultimately, because you were someone that was in Mr. Gutierrez's phone when that scene was found, did you speak to law enforcement about your friendship with Mr. Gutierrez?
Yes.
And did you offer to them all the information you had regarding anything you knew about him?
Yes, I did.
Okay.
Yeah. But he told Sadie met 2 of his kids. He has 4 kids,
And in fact,
this woman
during
only
your
knows about
time
1
of
kid.
talking via the phone for those couple of months, there were times you were actually in Kenosha physically and you two did not meet up, correct?
I was never in Kenosha.
Oh, you never met up in Kenosha?
No.
Okay. So you and Mr. Gutierrez never had any plans to meet up as of May 17th, 2020?
He wanted to meet up, but I never went.
Okay.
I have nothing further. Thank you.
Well, that was wildly short.
Nothing further on redirect. Nothing further, Judge. Thank you.
You may step down, ma'am.
Oh, okay. Thank you.
Wow. Okay.
Pretty anticlimactic.
Like totally. Oh, and I did miss Berserker.
Judge, at this time, the defense would like to make argument. We have witnesses. There was a development where the state had talked to an individual today. Sure. So we don't have witnesses ready now because of the development until the afternoon. So we're hoping to take this time to make the arguments that we would have made earlier and to instruct the court on where we're going to be moving forward.
Okay, this is going to be the directed verdict section of the trial here. They have to go through the motions. And I missed Berserker. Berserker had a super chat. The defense should bring in a crime scene cleanup expert to explain just how hard it is to get rid of all the blood and DNA from a scene and prove that there was no way to cut up a body in the van.
No, it wouldn't be.
I agree.
What did you say? Ah, bless you. You have no idea how wonderful you people have been.
At this point, they're sort of captives, Judge. So we're.
Well, I know it, but they could be owly too, and they're not. I mean, I've had cases where the
judge is just rambling now.
Anyway, let's break and come back at 12:30. Please don't. Read, watch, or listen to any account of the trial.
Oh my God, we're already at lunch?
Including fellow jurors or household members.
Early lunch.
Anything about the case, and 12:30.
12:30. So right now it's 1:12 here. 12 a.m. in Eastern. Yeah, they're taking the lunch break now. Hayden, wake up. Hayden, I hope you're awake so I can go to sleep.
Oh no, Jeff.
Wow.
You don't get to sleep.
Yeah, I guess not.
You
It's
have to
Friday.
stay here forever.
Oh God, of course I do.
You're like a state witness.
Well, let's go through this. While we're go away. All right. Niklas Starow, Union Rep, Labor Law. Who are you? Why are you here? And grift your channel for us. Where can we get a hold of you? Where can we find you? What are you going to do?
Jeff, I'm being law cucked right now.
Oh no. I'm so sorry. I'm so sorry.
It's okay.
Wait, never mind. We're going to have arguments. We're going to go through the motions of the directed verdict.
At the close of
whatever
the
you want to
state's
call
case, it's required under appellate case law and for the defense to make a motion generally as it relates to whether or not the state has presented enough evidence that any reasonable jury could find the defendant guilty. And what I want to do is talk in particular about, and I'll start with count 2, because there is a failure of proof with regard to that charge. That is the stalking, where Rosalio Gutierrez Jr. is the victim of that. And as the court is well aware, when we look at the jury instructions for
I think
stalking,
they can convict him of stalking at this point.
it is committed by one who intentionally engages in a course of conduct directed at a specific person that causes that person to either suffer serious emotional distress or to fear bodily injury or death to himself or herself, or a member of his or her family or household. And that would cause a reasonable person to, again, either suffer serious emotional distress or to fear bodily injury or death to him or herself or a member of his or her family or household. And where the actor knows or should have known that the conduct would cause that person to suffer serious emotional distress or to place the person in reasonable fear of bodily injury or death to himself, herself, a member of his or her family or household.
Come on.
So
you
the
should
state
know
has
me,
presented
Julio.
no evidence at all concerning Mr. Gutierrez either perceiving such a serious, and again, it's not just any emotional distress, but serious emotional distress, and or anything about bodily injury or death, any apprehension of that. Of course, another way that that can be brought in is if it would have, well, a second element actually is that it would have caused a reasonable person to have those same beliefs. The only evidence that has been introduced at all regarding the effect of these activities on Mr. Gutierrez himself was specifically that he was not afraid of Mr. Anderson in any way. In fact, there were some, we might call, jousting, not afraid of this guy type stuff. And there hasn't been any evidence presented by the state that would fit those elements as it relates to Mr. Gutierrez at all. So the fact that there's no proof on that element that's been introduced by the state, that should be a directed verdict of not guilty.
He doesn't even believe that.
I want to talk about count 1 because there was some evidence that was received relating to Ms. Beecham's apprehension of emotional distress. There was one point.
I'll be right
she
back.
testified that she was, quote, fearful. There was also evidence introduced surrounding all of the other circumstances, how she felt in response to it, what her reaction was, and things she did in response to them. Now, it's important to note that when we have, and I'm going to make an analogy here to the law that we understand as it relates to simple disorderly conduct, and you'll see why in a second. Because as we know, there's activity that we as a society are willing to tolerate within the bounds of normal and sometimes difficult interactions between human beings. And the court's well aware disorderly conduct is an example of that because it has to rise to a level where it's outside the scope of what we would consider to be tolerable activities, given the fact that people do have difficulties in life and sometimes do express themselves in ways that don't rise to that criminal level. So complications and arguments and some jousting going back and forth, some argumentation going back and forth, practically all of which was in the context of the children, but also what could probably be characterized as just normal friction that goes on when there's the ending of a relationship. The fact that Ms. Beecham had, and as she testified in the stand, at one point she did use the word fearful, but there was no evidence that this was serious or severe emotional distress, and no evidence that she was fearful for her actual safety or life. So, taking the evidence as a whole, there is not, in our opinion, sufficient evidence that any reasonable jury could find Mr. Anderson guilty on count one either. And again, I acknowledge that there was one statement where then she used the word fearful. That was all she said. Now, the most complicated aspect of this case, of course, is the fact that the state has charged in count 3 first-degree intentional homicide. And of course, that relates to causing the death of Rosalío Gutierrez Jr. with intent to kill that person as a Class A felony. The state has established, I think it's reasonable to state, and a reasonable jury could conclude that he is at least missing, and it's not an illogical step for the state to argue that he is in fact dead under the circumstances. So we acknowledge that. But the fact that and Mr. Gravely himself put on a great deal of evidence about how extensive the investigation, all the different places that they looked, and one would have to believe that with all of those resources at the state's disposal, that something more would have come up. So I know this is very difficult to quantify in any particular way. There's no mathematical formula here, but the state would ask, the defense would ask the court to determine if the state has met that threshold as to whether or not the state has produced sufficient evidence that would enable a reasonable jury to render a guilty verdict at that point. And the same argument really goes for count 4, because acknowledging that there is evidence that could be perceived as somebody removing a corpse if the person was dead from the apartment and then doing something with it. The only real evidence of that is the missing rug, the amount of blood, and arguably this other spot that was in the car. And assuming, of course, that the cutting out of the rug is something that the state believes that they've established timeline-wise.
You have.
So again, hiding a corpse, there isn't a corpse, and it's again one of those complicated situations that the defense would ask the court to determine if a reasonable jury would be able to find the defendant guilty of that count. So with regard to counts 3 and 4, I think those are pretty much traditional arguments that the defense makes in these types of situations. But I, again, on count 2, would emphasize there's been a complete failure of proof on the elements of causing Mr. Gutierrez to suffer either serious emotional distress or to fear bodily injury or death. And then again, with regard to count 1, relating to Sadie Beecham, that with the exception of her use of the word fearful, which we'd argue doesn't rise to the level of serious emotional distress, there's been a failure of proof with regard to that as well. And we'd ask the court to direct a verdict with regard to that as well. So we're asking for directed verdicts on count 1 and 2. We're asking the court to dismiss counts 3 and 4 on the basis that the state hasn't produced sufficient evidence to enable a reasonable jury to come to the conclusion.
Thank you, State.
And speaking of the internet's most hated person right now, it's Megan Fox.
I'm looking at the jury instruction.
Is that true?
No, it's not true.
Don't listen to Jeff. Never listen to Jeff.
Serious emotional distress.
I know, Jeff, you were like, get in here.
It does include
talk about Twitter haters. I'm like, who?
Which is to feel terrified.
Hi, Megan. Nice to meet you.
Those things are included, but unfortunately for the defense argument, it also includes harassed in that definition. So again, that's the bracketed definition of suffer serious emotional distress in jury
People
instruction
love to hate
1284,
Megan,
which
but
is
we
the
love
official
to
jury
love
instruction
Megan
for
because
Wisconsin,
Megan's awesome.
for the court to read for stalking. So in this case, certainly both of the charged persons who are victims, alleged victims in this particular scenario, would have reason to feel harassed by a series of incidents. And as the court knows, in terms of a venue statute, if any one of the requisite acts occur in your county, then you may use other counties' acts as a portion of that venue. In this case, the course of conduct required by stalking is at least 2 acts. We have alleged and have now abundant evidence from the state's perspective that on April 25th, the defendant at the home of Sadie Beecham, so that's not in Kenosha, but would be in terms of the course of conduct, something that meets the venue statute, that he peeped in a window, observing both Sadie Beecham and Rosalio Gutierrez, and that he broke into and took items from the truck of Rosalio Gutierrez. I think the court has heard the evidence of that, including that documents that are consistent with that were brought up to Sadie Beecham, that there's on the defendant's phone, there's a picture that can only really be explained by his removal of an item from Rosalio.
But that's stalking, not murder.
The defendant himself has admitted to various parties that he peeped in the window.
Stalking, not murder.
That to law enforcement and observed those 2 persons. So that certainly would cause any individual to feel harassed at the very least. The defendant then, on May 8th, plants a phone in the car of Sadie Beecham. That car comes down to the Kenosha address of Rosalio Gutierrez. Again, that's done for purposes of essentially harassment and monitoring, which is again harassing, and that's harassing to both of the 2 individuals. And then on May 13th, we provide evidence that the defendant is again eavesdropping at this time in Kenosha at the home of Rosalio Gutierrez. Not only does his phone place him in Kenosha at that time, but it's the very same phone that is using to text.
But aren't stalkers more likely to kill you?
Literally inside the house of Rosalio Gutierrez.
I don't know anything about this case, though.
The phone of the defendant is in Kenosha, based on the evidence the court's heard from FBI agent Hannah Judd. From that same device, he is texting the exact words that Rosalio Gutierrez has just uttered. Again, this is communicated to Sadie Beecham, so this is the defendant wishing that to be communicated. And so, again, is a second incident of eavesdropping, not at Sadie Beecham's home, but at an individual's home in Kenosha. The court heard both of these individuals express distress in various ways. Again, it's a reasonable person standard. Would a reasonable person who has had a phone placed in their car and who has been peeped on twice in a 3-week period feel harassed?
He's a peeper?
Would that be what a reasonable person would believe? And I think that there's a simple answer to that. What a person of ordinary intelligence and prudence would consider about that.
Ex-boyfriend apparently allegedly jealous of the ex-girlfriend, so murders her new boyfriend.
One of those, per the stalking jury instruction.
Who's the guy with the man bun? The defendant?
The defendant knew or should have known at least one of these acts constitute a course of conduct, again, that would cause someone to feel harassed based on what I have just described to the court. Well, each of these would be something that a reasonable person would believe would cause someone to feel harassed. So, again, I think we've met the stalking statute as to both. And again, Rosalio Gutierrez mentions to at least one friend that's in evidence, hey, this is happening to me. Certainly there are a number of texts between himself and Sadie Beecham where they express significant concern about what's happening. Rosalio Gutierrez even talks about, having a confrontation with this individual. This was abundantly presented in cross-examination in this case. And that is a sign of an individual dealing with feeling harassed in a situation. It's a very logical reaction to feeling like some person you don't know is harassing you. So that I think that there's abundant evidence of stalking as to both of those 2 per the presentation I've just made. As to the homicide, I'll go right to the element of causing the death. The court has now heard 3 members of the Wisconsin State Crime Lab. I think I count over 40 total years of experience in crime scene investigation and blood evidence from those 3 individuals. The court knows the State Crime Lab have many of the preeminent experts in this area in our state. They have all offered the opinion that this particular thing located in the defendant's van, simultaneous with seeing that shortly before, per the evidence in this case so far, his van has a cutout section that would be an area sufficient to store the body of Rosalío Gutierrez, at least for a short period of time.
These directed verdicts never go through.
Found,
the defense just has to do it
is in fact the DNA
for
of
protocol
so
and for formality's sake. The judge almost never, I've never heard of a single case where this
motive with
where this
all of the
directed
other
verdict
things
has
that we've
ever
talked
been
about
granted.
happening on April 25th, the 8th, and the 13th. And then with the significant deception that the defendant engages in his interaction with law enforcement on May 19th, combined with the rest of the evidence we've presented in terms of circumstantial pieces, from the state's perspective, we have provided sufficient evidence for any reasonable jury to conclude a homicide has occurred. Thank you.
Thank you.
Just briefly, very quickly, Judge. The argument that Mr. Gravely just made with regard to the reasonable person aspect of stalking only relates to element 2. That is, the course of conduct would have caused a reasonable person to either suffer serious emotional distress or to fear bodily injury, etc. But the important thing here is element 3 is that the defendant's acts did cause that person to actually suffer serious emotional distress, induce fear of bodily injury or death. So that's what we're missing here, is that there's been no evidence of that.
Well, again, the definition of suffer serious emotional distress, which is located in 2 and 3, is the same, which is harassed, which includes the subsection harass.
And again, just briefly.
Well, no, that's your point. You're combining the act with the cause with the effect. You're merging them into one concept.
Yes, we're already one witness deep into the defenses.
The definition remains the same.
Oh, I'm not arguing that.
There's still a lot more defense to
you
go.
Both have to, the conduct and the result, but the result is the result of the words suffer serious emotional distress can include that the individual involved feels harassed.
But that still doesn't cover both elements that we're talking about, 2 and 3. Really, well, the reason, logically speaking, the reason why element 2 exists is that we're adding a reasonable person standard on top of the actual causation that's represented in element 3. So presumably there could be a situation where somebody is overly sensitive and wouldn't be that reasonable person standard, which is why the state has to prove that additional aspect of it. But also, I think it's a leap to say that eavesdropping on somebody is harassment. And that's essentially what the state is saying. But checking in on the mother of your children and see what she's doing that doesn't rise to harassment necessarily.
I don't know about that. I'm not having such trouble, but I guess
I've missed Judge Schroeder.
Step being skipped here.
He's deteriorated since Rittenhouse.
Has he screamed at anybody for being too brazen yet?
Harassing behavior by the defendant.
He did use the word once.
And
little scolding here and there.
Before the
Don't get brazen with me. There's evidence there from which the jury could conclude.
Bring that guy back.
That element is present.
It's his glasses.
Defendant's argument, as I understand it, is that where's the evidence?
He doesn't look so good.
That the defendant's acts had the effect of inflicting.
Is he falling asleep? He's contemplating.
He's been a little sleepy throughout this entire thing.
One of the subsections
kind of
in 3
meandering
is caused Rosalío Gutierrez to suffer serious emotional distress.
Right.
So yes. So the second element here is what would a reasonable person be feeling out of this, right? That's the second element. The third element is what did the named victim feel out of this? But the definition remains the same. That when you opt for to suffer serious
Bring
emotional
in Binger.
distress, whether you're speaking about the reasonable person,
This is Binger's
or you're
boss,
speaking
the
about
actual district attorney.
himself.
No
This is
way.
Binger's
No, don't
boss
bring
here.
Binger.
Definition of
Jeez.
suffer serious emotional distress.
I don't even know how that guy has
happens in
retained
those
his
change of elements is what
license
would a
to
reasonable
practice,
person
frankly.
feel, and then what did the
He
purported
should have been
victim feel?
sanctioned.
In this case,
I agree
the way
entirely.
you do that, you can't read the mind of individuals, right? We know this, right? In all instructions,
He's
it comes
82
from
years old.
The acts and circumstances.
Yeah,
You
he's
would
an
never see this
octogenarian.
person,
Everybody
right?
be nice.
So,
I love
otherwise you would never be able to
Judge.
stalk a person.
Has
if you managed to
Lunchbox
murder
made an
them.
appearance?
You'd never be able to do it, right? So
Yeah.
the
That's too
third
bad.
element here is what
No, but Natalie
what
Wisco has come on
impact
stream
would this
several
have on
times.
Rosalía Gutierrez?
Really?
And within the
Yeah,
definition,
she's awesome.
suffer serious emotional distress. One of the options is, did he feel
She's
harassed?
had some great insight.
Okay, so what is the element? What are
Somebody
the,
said
what are the
Judge's wife
pieces
is
of
having
evidence he
health
felt harassed?
problems.
Well,
That's
he
not
told
good.
an
Yeah.
individual that he felt that this person was a
And he
problem.
did have to take off early for a day.
And if the court remembers, the court limited that evidence
Like for
on,
an hour
on
one
various
day
times. We
to take his wife to
described
some
that
appointment.
we were wanting friends of Rosalía Gutierrez to talk about how he had
I feel the
identified
same.
an individual who was a problem for him. But we did manage to get one individual to be able to say that. And in their text messages back and forth, which were covered extensively, Judge, it's clear that Mr. Gutierrez is feeling harassed. And I told you, I think the most clear answer about that is the way he is planning on solving the issues that are related specifically is he's thinking, I will go over there. He does as much as collect the address of this individual. And I think that's the most rational and logical way that one would respond. So elements 2 and 3, the only change is what is a reasonable person going to be impacted? And then
The
element
jury is
3
not here.
How about the victim himself? But it's the same definition of suffer serious emotional distress. So certainly a reasonable jury could say, based on the facts we heard, Rosalía Gutierrez is someone specifically who would feel harassed here.
If I may.
Well, they didn't. The legislature did not use, or at least, yeah, this is the legislature. This language is taken from the law itself, not just a pattern instruction from the committee. But they didn't use the word annoyed.
Didn't use what
They
word?
didn't
Sorry.
use the word annoyed.
No, they didn't.
I'm annoyed.
They chose harassed.
They chose intimidated, threatened, terrified, harassed, or tormented. Now, we had a case in here a couple of years ago. Not you, but a couple of people from your office, and
You guys argued the opposite. Guaranteed that's what he's going to say.
Yeah.
the prosecutor, well, all of our names who were involved in the case, our addresses were published on the internet.
Oh,
Doxed.
My children's names were
Doxed.
published on the internet.
Uh-oh.
What
Is
the
he talking about Rittenhouse?
goofball thought
Rittenhouse,
were my
yeah.
children's addresses were put on the
Well,
internet.
all of that stuff is public, Judge.
All wrong.
I can find your kids' names in 5 minutes.
So I was annoyed.
It's true, but when you do it with
my
the
family.
intent to harass
I made them
and
aware of the
to
situation,
torment.
but
I don't know, though.
Well, even he's saying
in
I'm
the case
annoyed,
of
but it's not.
at least one of your
It doesn't
assistants,
rise to the level of what they're
the
asking.
correct information.
Yeah, I think what he's saying is it was annoying,
and you know,
but it wasn't
what,
terror. It wasn't terror.
he went through. I don't know. I don't actually know what his reaction was. I know what a reasonable person would have felt: terrified, intimidated, threatened, tormented, and harassed.
Yep.
That's what the reasonable person would have felt. And if you told me that he was any of those, I would say it makes sense to me.
But
And
Yeah, there's
I
a but
think
coming.
the significant difference is that in my case, I knew the information was faulty, so I was still very annoyed but I would not qualify myself as having fit into those categories.
It wasn't real information. That's
So,
great.
um,
They got it wrong.
It depends somewhat on the nature of the provocative behavior. And the question is not whether, there's. I won't talk about your assistant, or I won't talk about myself. But there are people who would react to that by searching the person out, beating the living daylights out of them.
Oh, really?
Oh,
happens all the time. That's our
Happens
business.
all the time.
And we deal with
all the time.
cases on a daily basis.
Wow. So watch out, doxers. Somebody might beat your ass.
Bad boy,
Okay.
bad boy. What you gonna do? What you gonna do?
I'm
when
not
the
sure.
finger comes for you.
Terrified, intimidated,
Did Schroeder beat
threatened,
someone's
maybe,
ass?
harassed, tormented.
That's what he's saying. He's
You're
saying you
talking
did
of-
it.
now, we're
If
not
you
talking
had
about
done
the
it
reasonable
correctly,
person.
I'd
We're
have been well
talking
within my
about,
grounds to go beat some ass.
Mr. Gutierrez.
Put that on a t-shirt.
And if that element were written as being annoyed, I would quickly dispose of this motion.
This is what happens if you're annoyed. Let me show you what happens if you're annoyed here real quick.
Sometimes you just got to take a beating. That's funny. That was hilarious. I think he just admitted that he
Private
beat someone's ass.
conversations inside the home. This is I would say to you that's the definition of harassing someone. That is the definition of harassing someone. If somebody was outside your or my window when we were in the
So
privacy
really
of
what
our
the
own
judge is
home,
arguing is what
and
the
they
reasonable
were then
standard
communicating
is,
to people
and what
that
a
we were
reasonable
close
person
to
ought
and
to
saying,
feel in
here's
this
what I'm
circumstance,
observing in there.
and whether or
Here's
not
what
there's
you
a
just said
disagreement
inside your house.
Yeah,
between
that
jury
proves- that
members
would
about
prove
whether or not they would
what
also
a
feel
reasonable
correct.
person's reaction would be.
But this is a deceased individual. So how? I mean,
don't know
so,
that. We
so
don't
the court
know he's deceased, right?
knows that those things are.
I can't presuppose that, by the way.
He has not been
I'm
declared
not the
legally
jury.
dead. He is missing.
We cannot look into the mind of an individual in this situation. We cannot do that. So except what I've told you already, what I've already shared with you, which is we've shared extensive email information back and forth where he and Sadie talk about how the stress of this particular experience, right? They're communicating about this. And Rosalio Gutierrez's reaction, shared with the jury, is, I think I'm going to take care of it. I think I'm going to go find this guy. I'm going to deal with him. And they even have a conversation revealed in the text messages about the address. So the court indicated, well, if someone shares your information on the internet, that might be your same situation. Yes. But the added information the court has is that what Rosalio Gutierrez knew at the time was that his information was he had been literally peeped on twice in private residences, where then the information obtained in that peeping on him was being used to taunt people. And I'm not even talking about breaking in his vehicle, which of course is something that is a worry as well, private information. Right? So, for instance, what happens is a letter is taken from his vehicle, and that letter is utilized to try to indicate that Sadie should be watching out because he's actually in some other relationship. It's being used in a way to try to harm Mr. Gutierrez.
The statute deals with effect, not cause.
This charge
You're
might
talking
get
about
dismissed.
cause.
Right.
You're talking about effect on a reasonable person, and the motion, as I understand it, is the effect on Mr. Gutierrez. He's dying to talk again, so I'm gonna let him.
And I'm being so patient, Judge, because I didn't want to interrupt Mr. Gravely. But I'll quote from a very significant text from Mr. Gutierrez. I'm not worried about it. It's exactly what he said. And the argument that one is guilty of stalking, and the most compelling proof of that is the fact that Mr. Gutierrez wanted to beat down Mr. Anderson. That's stalking. So that he had a reaction
There are
like, I want to take
texts
care of this, I want to deal
from
with it, and simultaneously
the
saying,
ex-girlfriend
"I'm not really
saying,
worried
"Let's
about it."
break the
You
defendant's
know,
legs."
I think the court's right.
Oh
It
my.
may be something that one gets annoyed by, which is why I had the discussion about for something to rise to the level where it's criminal conduct, this type of criminal conduct, that it needs to be, an actual effective harassment. And the most, I get a bunch of fancy arguments here about how, and again, he's focusing on reasonable persons, but we have evidence that it didn't bother Mr. Gutierrez from his own words. And in fact, one could glean that he almost found it amusing that he was going to break his legs or call somebody up to do something to him. But you can't prove that one's harassed because they want to beat you up.
That's fine.
Well, I think that I cannot, and I think this is the appropriate test. I can't exclude the possibility that the jurors will see it as Mr. Gravely does, and that a reasonable jury could come to that conclusion. When you use the word terrified, as the statute does, that kind of shoves aside a reaction like, I'm going to go confront the guy and I'll take care of this. That to me is more the reaction of an annoyed person rather than a terrified one.
Terrified person. Yep.
It's not. I'm not so sure of that I would.
If he tosses
grab
this,
the
though,
issue away from the jury, so I'm going to.
that's going to impact.
Just so the
the
court, the
state's theory.
subsection says "or." So terrified is.
Steph, the alternate in the chat. Hey, Steph.
What's up, girl?
Love you,
Love
girl.
you.
The court denies my motion,
Happy
but he still
St.
has to
Patty's
add
Day.
something to it.
Well,
We're
let's
done.
now come on now. Let's play nice. And your other motion with respect to the fourth count, did you make some comment on that?
With the hiding corpse?
Yeah.
Very simply that, we don't have a corpse, and I know we don't have to have one.
You don't have
the
a corpse.
evidence of.
You also
again,
don't have
the
any
aspects of
DNA or
that.
any other evidence.
Similar to count 3, I simply asked the court to analyze the evidence as to what evidence there is that a reasonable jury could find that Mr. Anderson himself, as opposed to anybody else, hit a corpse with the intent to avoid apprehension for a crime. And I acknowledge that if there is a corpse, if there is a death, which I know that the state has to prove that. As
We
part
don't even
of
have a
this.
body?
But
Wow.
even supposing
Nope.
that,
No body, no weapon, no evidence, nothing.
I'd ask the
So
court
we
to
don't
make
even know
that
if the guy's
determination.
dead. He might not
We
be
do
dead.
not know
make
if he's
motion
dead.
in any
Correct.
Well,
in a
if the
shed
jury
somewhere.
is
And the
satisfied
defendant's DNA
of the
is
state's
nowhere near the
proof
crime
on
scene
count 3,
whatsoever.
then there was a
Kinda goes
body and it's gone. And there's evidence from which the jury could conclude that it was the act of the defendant that led to the removal of the body. So motion is denied.
Yeah.
Yep.
What else?
That was easy.
Directed verdicts are
The
always
defense wanted to
They're
just
really difficult.
inform the
to
court
get.
of where we are witness-wise for the remainder of the day. There was a development where the state had talked to an individual, and that nixed the necessity of 3 witnesses we had lined up for this afternoon. So now, instead of having 6 witnesses for this afternoon, the defense only has available 3. However, we believe that those 3 will take up this, if not the whole afternoon, the majority of the afternoon. So that's the 2 witnesses who are in custody, Marquand Washington and Nicholas McAtee. And then we have an officer witness available to testify after that. As far as the other witnesses, due to their commitments and availability, we have them all lined up for Monday. And we have a remainder of, I believe it will be 8 or 9 witnesses for Monday. And
Wow.
so given that the majority of these witnesses are short, we would include
vertically
resting-
challenged,
we would
not short.
expect to rest on Monday afternoon.
Wow.
Well, do you have comment, by the way?
No, I appreciate that council has tried to keep me appraised of our developments, and so and that is why we were able to remove 3 witnesses. So I mean, I guess I want to tell the court I think that development was a positive one when we interacted, we were able to check some things that I think allowed them to not need to call those witnesses. So no, I think that is the current schedule, and I defer to them about how many more witnesses they have or where they think the schedule will take us in terms of that.
Well, first off, the last word spoken in this courtroom this afternoon will be at 4:30. That is the last word in this courtroom this afternoon.
Meaning we're not going past that, is what I think the court
You are
said.
so right.
But that doesn't think about what happens if we're done at 4 and they have no further witnesses.
You know what? I'm not going to go to the complaint department if you.
Very
want.
good. Okay.
But just so you know, you're not.
Nothing past
going to
4:30.
be, the muscles will go on at 4:30.
Gotcha.
That's number one. Number two, no matter how many witnesses there are on Monday, and you tell me that you consistently refer to short witnesses, and we've had a few. I think you mean brief. No matter how brief they may be,
St. Patrick's Day.
Be ready for instruction, and I do instruct first. Be ready for instruction on Monday, which is why any requests that you have on verdicts or instructions will be due at what did I say when we were talking?
At 5 o'clock Sunday.
5 p.m. on Sunday. Send it to my email that you've gotten on prior communications.
Aussie Overlaw'd, Hayden in the house.
And
Jeff's just stoked he can go to bed.
List the instructions by number unless you have changes. If you have changes,
Okay.
you need
All right,
to
let me
set
get
forth the full change you want. And highlight the differences between the standard and what you want. Before I probably sometime before noon tomorrow, I hope, this is
what?
Not for sure, but I will hope to send you a preliminary draft of the boilerplate stuff.
And if the boilerplate stuff is what we anticipate, then we do not need to communicate with you at 5. If we have no different.
Just tell me you're comfortable with everything.
Very good. So you still would like us to communicate and say something. Got it.
Recommend it.
And just so I make sure I'm understanding everything, if we're just asking for the standard instruction, we can just simply include the number. It's only if we're asking for a change to include that and the difference.
That is correct, and I did mention when you were up here before that I don't. The statute I think is a little difficult to work with in terms of making a fully intelligible.
Judge, you are not
statement to the
fully
jury of
intelligible.
what exactly needs to be proved. So while I'm not demanding it of you, the form that was in the preliminary instructions, which I will repeat in the ones that are sent to you over the weekend, that follows the what's in the information. And I think it's awkward, but if both sides are comfortable with that, far be it for me to jazz around with your case. Was there something else?
No.
I don't think so. Anything else from you folks?
Back at 12:30.
Well,
Please.
can we have lunch? I mean, we can't go get lunch and be back by 12:30.
Please, Judge, can we have lunch?
We're so hungry.
I want lunch too. That sounds delicious.
I'm
Well,
hungry.
there's fast food available. Yes, and you can even have meat if you like.
Oh, they want the judge's meat.
All right.
So what time should we be
It's that corned beef.
Okay.
No, the jury's been so good.
Yeah.
And I feel like such a traitor if I give you more time than I give them and have them sit up there in the dungeon.
The dungeon.
I probably won't lift my voice if you're here by 12:40. Okay?
Thank you, Your Honor.
Now, let me just ask this, is there a medical reason why you need longer? Oh, okay. No, you have to eat, but I just,
Wow. Okay. Megan, any questions?
God, I have so many. So I've been trying to catch up while we're listening to this on what's happening here. And what I just read on Court TV, and you can believe everything that you read
absolutely.
on Court TV. I just read that he was reported missing, Gutierrez.
Yes.
They conducted a welfare check, discovered large amounts of blood. How much is large amounts of blood?
Oh, okay. Okay. What happened was he stopped talking to his current girlfriend, who is the ex-girlfriend of the defendant, on the 17th of May, 2020. She hadn't heard from him in about 12 hours, so she panicked and went to his house. She's weird. She's controlling. She's a freak. She went to his house and opened his door, just walked into his house and saw blood everywhere and called the cops. And the way the defendant, the prosecution presented this in the opening statements was they said there's a small rug missing in the living room. And except for the void where this rug was, every livable surface in the house was covered in blood. But it turns out that it was just kind of, to me, it looks like someone like cracked their head open on a end table and bled a lot and then sat on the couch for a minute. And that was it. I mean, there's not a lot of blood. It's really not, there's no way a human could have bled out.
Then Court TV is also wrong about this because they said authorities found Gutierrez's blood in Anderson's Dodge minivan, which
That
was
is
also,
incorrect.
missing a large section of carpet and smelled of bleach, according to the complaint.
Okay.
So what's
And
with
let
the
me tell
missing
you what
carpets
that is.
everywhere?
It is his work van. He is a contractor. His job is to demolish houses and to like carry out, and every person I've ever known in my life that is a contractor and works in demolition, the first thing they do is rip the carpets out of the van so it doesn't get ridiculously dirty.
Yep.
But what there is no body. There is no murder weapon. It appears to be a blunt force trauma spatter because there's blood spatter marks on some of the walls.
Little flecks of blood. Mostly flecks of, what looks like
little
blood,
flecks.
but maybe is enchilada sauce or salsa. We're not sure.
Exactly.
It's
so there's no body, no murder weapon. The defendant's DNA is anywhere related to the crime scene.
Would you tell the chat to calm down? No, of course I don't believe Court TV. That's why I said, of course, you have to believe everything Court TV tells you. I was being sarcastic.
Sarcasm.
Oh my God, calm down.
No sarcasm in the classroom.
I'm trying to figure out I've never heard about this case. I'm trying to figure out what did the Court TV tell us and what actually happened, which is what Jeff is telling me right now.
Yeah.
So shut up a minute and listen.
Shut the fuck up, chat.
Can I take the blood in the van question for Megan?
I like you, chat.
If you feel so inclined.
Danny, don't be a suck up.
I am a suck up. I love chat. Chat
I
gives
like
me
chat
money and
too.
chat subscribes to my channel. So
Any
love you,
female that
chat.
sucks up to me is welcome. All right. Anyway, continue.
I was going to say, so Megan, you asked specifically about blood in the van, right?
Yeah.
So the claim is they found the victim's blood in the defendant's van. Okay, so they looked in the van, and you also said something about it smelling of bleach. Okay, so when you look in the van, so the van is completely filthy. The carpet has been removed from like the third of the portion of the back part of the van. And they found one tiny little fleck of material that looked like blood that was too small to test for both DNA and blood. They tested it and they could not rule out that it was the victim's blood.
Okay, now Chandler, you still have to go back a little bit. Yeah, you still have to go back a little bit because this is. I mean, I will give the prosecution that if the jury came back and said he's charged with 3 crimes, well, 4 crimes technically, 1 murder, 2 hiding a corpse, and stalking the alleged victim and stalking the alleged victim's ex-girlfriend, who is his girlfriend. Well, the alleged victim's girlfriend, which is his ex-girlfriend. So there's 2 stalking, 1 murder, 1 hiding a corpse. I would be willing to concede that he was stalking them. I mean, it's kind of a 50-50 one way or the other. If the defense acquitted, I would get it. If the defense convicted, I would understand. But what happened is there's this back and forth. He was jealous. He has 3 kids with the ex-girlfriend. He is applying for custody of the children. The girlfriend doesn't want that to happen. So
his
her
lawyer
and the
probably
boyfriend,
told him to do all of this. Probably.
her
You
and the
know, like
boyfriend.
get the recordings of them talking so
Yeah.
they can use it in custody court against him.
Well, that's what the ex-girlfriend's boyfriend was saying. You make sure you manufacture a paper trail. And if that doesn't work, we can enact plan B. And then they sent texts back and forth like, what if we just break his legs?
Oh my God.
I'll do it if only if you say it, but if you want that, that's what we'll do. There was some stuff like that. But like I said, there was none of the defendant's DNA at the crime scene. But what they have said was the defendant was jealous and broke into the ex-girlfriend's current boyfriend, who is the deceased, broke into the alleged deceased. There is no body. Broke into the
Is there
alleged
any
deceased
evidence of a
car.
break-in?
Yeah, well, they said that they broke into his car and took his registration and something else. I can't remember because I'm liquored up out of his car. And so in retribution, the ex-girlfriend said, well, he knows your address, so you may as well know his address. So the ex-girlfriend sends the defendant's address to her current boyfriend, and he goes into the defendant's car and does some stuff. So that's why that's what they're saying there. Like, he was in the defendant's car, so that would explain this DNA. And what this DNA is in this entire gigantic work van where the prosecution wants you to believe that the defendant is probably 6'1"-ish, maybe 220, 230. The deceased guy was 270 pounds. And
Big dude.
the prosecution has said that the defendant has a bad back and has disc problems.
Oh boy.
Yeah. So there's all of that. But they found one, and everybody in the prosecution's witness said it is a pinprick sized spot that was so small they couldn't do a presumptive blood test.
That shouldn't be admitted. That shouldn't be admitted if you can't say what it is. You can't tell a jury, we think this is the defendant's blood, even though I can't prove. I mean, the victim's blood, even though I can't prove it. That's insane.
Oh, that's exactly what they did, though. They specifically said they got one CSI tech on the stand that said, I can say with a certain degree of scientific certainty that it is the victim's.
Yeah, it's in my
blood.
Opinion, it is it is blood. And
what
so what they did is
there
this
that?
was so small. They had a choice: test it for blood or test it for DNA. That's how small it was. And so they decided to test it for DNA. And the best they could do was say it was a single source. Only one person contributed to this DNA, and it was a male.
But it could be the defendant's then.
Yeah. Well, they said they could not exclude the defendant as the source of the DNA.
That's crazy. That shouldn't be allowed. How is that allowed as evidence?
Yeah.
Yesterday, they actually went through and said that they even actually couldn't put together a full DNA profile of the deceased because they couldn't find a chain of custody DNA strand, whatever. And because his father's missing, they could only build like a 50% profile to test against.
This is nuts.
Yeah.
All right. Well, I would love to
is.
stick
It's
around,
insane.
and I'd love to stick around, but I can't. I've got a phone call I have to make at
You do.
right now, so I got to run. But thanks for having me.
Thanks, Megan,
I
for
love you too,
popping in
Danny.
briefly to this shit show.
I know,
Megan
Danny.
Fox,
You got to come on
everybody.
my show soon.
Yes, absolutely.
Megan Fox, locals.com.
Thanks, guys. Nice to meet you, Chandler and Aussie. Good to see you again, Niklas. Nice to see
Megan,
you too.
you
Happy
rock.
St. Patrick's Day, everybody.
Happy St. Patrick's Day.
I'm so far into St. Patrick's Day. All right, so that's where we're sitting here with just this amazing shit ton of evidence. And what we just saw was the defense making a motion for a directed verdict that the prosecution has not even remotely proven their case. And virtually never will the judge grant a directed verdict. It's just a motion. Why do we do it? We have to go through it to preserve the appeal. That's essentially what it is. We're preserving the appeal so they can say, we did this, the judge ruled against us, and that was improper. So that's a grounds for appeal. That is literally the only reason we go through this, to preserve the right to appeal.
But it was almost like he entertained the thought of stalking the alleged victim.
Yeah. Well, while we're here, Niklas, grift your channel, Niklas.
Oh, sorry.
We're going to do the grift here. Grift away, Niklas. You are coming close to 1,000 subscribers. You're just like a bee's dick away from being monetized.
Well, I'm Niklas, but if it is easier, call me Nick, so you don't confuse us. And I'm a junior rep. I do labor law. And on YouTube, I try to do union stuff and labor law, but nobody watches that, so I entertain everything else. And yeah, I'm at 930 subs and counting.
And this is the literally the only speck of DNA they have of the defendant anywhere remotely. I mean, of the alleged victim anywhere remotely near him. And they can't even say this is the deceased or missing guy's DNA. This is a random spot in the back of a work van that they said is a single source DNA from a male who the person that collected it believes to a reasonable degree of scientific certainty that it is the defendant's, the victim's DNA. That is it. This literally one tiny pinprick spot. That's it. That's all.
Yeah.
That's it.
I've never seen
And I
that
believe
photo
it.
before. That is a lot smaller than I realized it was.
And that's
This is
that's a blow up picture as well.
Yeah.
Yeah.
Look at the size of the
amazing,
bolt
yeah.
here on the right side of the screen. That is a bolt. That is a tiny, tiny bolt, and that is it's smaller than the point of the magic marker that made this arrow.
Yep.
That is how small it is.
So it looks like Court TV might have exaggerated a little bit.
A little bit.
No.
Slightly.
Yeah.
So I'm sorry to interrupt you, Niklas. Continue your grift.
My grift. Okay. Well, what I'm having on my channel right now, it's since I'm in Europe, I follow the Andrew Tate case, and I had my latest video on that.
Wait,
me.
I'm sorry, Aussie. Come back. I accidentally bumped you. Sorry. Come back. Come back, Aussie. Continue, Niklas.
Yeah, and it's no secret I am not a fan of Andrew Tate, but that doesn't exclude that I am a bigger fan of due process. So in my latest video, I'm going through the latest court decision that surprised a lot of my audience. But that's why I hope I can separate my personal feelings from what's happening in that case. So that's the
what you're
latest
supposed
I've
to do
done.
as a lawyer. Yeah.
Yeah.
And you can find Niklas Starow at Niklas Starow Union Rep Labor Law. That is his channel name right there on YouTube. Go there. Let's get him to 1,000 subscribers.
I need 70 more.
Deal with that. And Law and Lumber, Rob says the stalking charge is BS with a text from the parties. Stalking requires an element of perceived threat of harm. Well, in essence, she specifically said, I'm not afraid of him. I am pissed that he broke into the car and took something that didn't belong to him. She said that in her texts.
She said, I'm not worried. I'm not worried.
Yeah, I'm not worried.
Yeah.
Exactly.
And Junior was more protective of Sadie than fearful for himself, I believe. Because he has apparently a lot of friends with shady pasts. So why would he be scared of some random dude?
Lots of shady friends.
I mean, he asked her permission, essentially. He said, we could, rough him up a bit, break one of his legs.
Break his legs, yeah.
Just give me the go-ahead. Just tell me that it's okay. Or, unless you say no, basically. I will make that happen. I know people. And then she goes, Poppy no snitch. which like I don't know what the fuck that's supposed to
Yeah,
mean.
I don't know what that means either. Yeah.
It was it cracked me up, and I think that everybody in chat really
Their
loved it as
safe
well,
word.
so, yeah, copying the stance.
And Danny on direct, my home girl, my ride or die girl, my what are we like alumni bros? What the hell are we?
Yeah, we're
Danny-
alumni bros. We're like a part of a sacred fraternity of coolness.
And I just
Except
heard that
not a
Professor
fraternity, 'cause I'm not a
Skabeen
dude.
died.
Huh?
I heard that Professor Skabeen died like a couple of weeks ago.
He did, probably because he
Aw.
got the anyway, yeah, no, so he did.
No, he had like
passed.
cancer. Yeah. Like
Yep.
one of my law professors died like a couple of weeks ago.
Oh no,
And-
that's
and
so sad. I'm so sorry.
Danny and I went to the same law school, University of Utah Law. Danny's a Salt Lake girl. She's my homie. Danny's my homie. But yeah, like Professor Skabeen, he was like one of the preeminent lawyers in the United States for Indian Native American law rights.
Yep.
And it was so long ago, I can't even remember what class I had him for, but he taught me for one of my classes. I think it was like international law or something.
That
But
sounds
yeah.
right. Probably before Giora, because he's been around longer than
Yeah, I
Giora,
don't know
think.
him. Yeah, I don't know him.
So.
But yeah,
Yeah,
Professor
nobody-
Skabeen died. I heard that. That was kind of sad. I saw that like on the internet. I was like, it's like coming from Utah. If you ever hear anything from like Utah in general, but my specific tiny little town of Logan up north, if you ever hear about Logan in the news, it's never for anything good.
It actually was in the news this morning.
It was. Well, why? What
Flooding.
happened in Logan? Flooding?
Flooding.
Yeah, because they had a lot of snow recently. Yeah, that's
Yep.
right.
Yeah, we're coming up on the 1983 record here in Utah. So
Oh, really? I remember
Yeah.
sandbagging. I remember like laying sandbags on in Utah during the 1983 floods. That's weird. But Danny on direct, grift yourself. It's so good to have you here. Welcome back to the internet. It's been a day or two.
I know. Well, I was supposed to be a glowy by now, but I never got a call back after that second interview. Now, typically with these types of Fed jobs, when you go for them, it's like a month in between each interview, typically. And then if you have to get your security clearances, it's a good 6 months, unless you're friends with the president or you're accepting Biden bucks, in which case you get it like overnight. Anyway, seeing as I am not receiving Biden bucks and I am not friends with any president, I had to take the long path, and I don't know how things are going to work out. But what I do know is I miss you guys. I love the internet. I had to come back, and I'm going to start live streaming daily beginning April 1st. And that is not a April Fool's joke. So come check out my channel.
That is so
I will
awesome.
be driving up to Idaho to cover the Lori Vallow case, because they will not be live streaming that case. Presuming that it starts on April 3rd is when it's supposed to start. I think they'll have a jury impaneled, and I will be there starting April 10th until the 14th. So if you guys are interested, come check me out. Woo woo.
I will
And we
definitely be watching that. That's
Absolutely.
awesome. I'm really looking forward to it.
And we currently have 2,120 concurrent viewers and 1,564 likes. So everybody get over there and smash that like button. But more importantly, right now, I'm trying to get to 36,000 subscribers. And where are we sitting? Currently, what do we got? We have 35,778 subscribers. So we need like 200 and whatever. 200 plus a little bit, because I'm a lawyer and I can't do math. 200 and something, 200 and like 25, 26, whatever the fuck it is, to get me to 36,000. Please do that. Hit that subscribe button. And while you're at it, just tap that like button and then take our stupid little poll here. What are we looking at currently? Currently, our poll says like and subscribe and vote. 10% of you say guilty. 63% of you say, okay, I was drunk, so I misworded this. It says innocent. It should have been not guilty. But yeah, we'll say the same thing. So 63% of you say innocent or not guilty. 26% of you say hung jury. Law and Crime is putting this at like 90% guilty. And like a few percent.
Yeah.
I mean, that includes guilty and not decided. But yeah, you guys rock. That is so awesome. Now, Chandler Remington. Who are you? Why are you here? Welcome to the internet. You're like focusing all the rage on you at the moment. Who are you and why are you here?
Hi, so I'm Chandler Remington. I am a paralegal. I live in California. I have worked in law for, I think, since 2018. I started, working at a law firm in college, and I am really happy to be here. I really love, I love watching trials. I was lucky enough to be invited by Jeff to, to come on to his channel, and I've been really enjoying streaming. So it's been a lot of fun. I offer more of a layperson's perspective because I'm not a lawyer, but I am about to take the LSAT in June, and I'm looking forward to going to law school and becoming a lawyer. So happy to be here. Just really excited to be a part of the panel.
And Aussie Overlaw'd. I mean, like, everybody knows you, but grift away.
For anyone that does not know me, my name is Hayden Glaister. I am the managing partner of Glaister Legal here in Melbourne, with offices in Southwest Victoria and across Melbourne. I run the Aussie Overlaw'd channel, where ordinarily between 4:15 and roughly 5 o'clock, depending on the start time, I do my usually daily show, Law, News and Laughter. On Sundays, we do Kinky Corner, which is always a lot of fun. And I've been awake for literally 15 minutes. So if anyone was wondering about the Guy Fawkes mask, it's because my face looks horrible.
I like the mask. It's a good look for you.
Yeah, there's nothing you can do about that. That's just nature. Sorry.
Yeah, well, I mean, I got up and I cleaned my face. I put the hat on because at least then didn't have to worry about the hair. But
well, I think you got to go like full on St. Patrick's Day. The green shirt, the green sweater, all of this shit comes from Ireland, except for the shirt, which comes from Finland. Oh, Danny's. It's like ancient early AM in Utah, and Danny's already got the green fingernails.
Danny, I love the nails. You've inspired me. I think I'm gonna have to change my manicure.
You have
really
to.
pretty.
I am
Do
obsessed.
it.
I should do like a nail reveal at every one of my videos because I
should.
love having
That's
my
a gorgeous
nails done.
color.
But
It's a good green.
the color is
And-
sea glass. Sea glass
Ooh.
green.
Oh, I love
And
that.
Niklas is a Shriner, whatever the hell that has to do with St. Patrick's Day. I'm not sure, but we'll give him the Shriner thing.
hang on,
but
Sindel,
yes,
I got you.
the hat. This is a hat from Aran Sweater Market in Ireland. This hand knitted, amazingly warm, super comfortable sweater is also from the Aran Sweater Market in Ireland. My shirt is green, but it's from Finland, and my watch is also from Ireland. It's a luxury, with the only luxury Irish watch brand, which is Nomadic. So we're going like full, and we're loaded with Irish whiskey and shit over here. So hey, happy St. Patrick's Day to all my Irish people from Ireland. We're glad to have you here. We got like 25 super chats. Let's burn through these, and then we can talk some more, and then we can turn this on over to Aussie Overlaw'd, which we do every day. John Diaz says, I think a crying kid on the stand. Blink, 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 dot, ellipses. All right. That's enough of him.
He's been kicking people. He kicked me out a couple of times.
Someone in chat
Speaking of-
specifically asked about it, so I said, yes, I have this
Speaking of
hat.
Kinky Corner, he's got his little dangly balls there. Hayden's balls are dangling on stream here.
Now listen here, Jeff. I keep telling you, you got to stop being nasty.
John Diaz, $5 super chat, says, I think a crying kid on the stand who's vehemently against the father is tough to overcome. Juries make emotional decisions. If he is convicted, it will be on the basis of his daughter's shit testimony. Hands down, no questions asked. That if he is convicted, it'll be because of her and the shit that probably should have been a mistrial. But anywho, here for the truth says, lol, you did a recap shortly after I sent the previous super chat. And that was sent. This super chat was sent like an hour and 8 minutes ago. So I have no idea what you're talking about. Sorry, here for the truth, but thanks for the $2. Wait. All right. I'm liquored up. Julie O. Hi, Danny. Long time no see. Jeff is wasted and might or might not pass out before you see this chat. I'm so far away from Pat. I've never passed out, and I've never thrown up from being drunk ever. I just
Love
can't.
you,
I wish I could. Thanks, Danny. And Tomb Zure 2. So he ghosted her. Ha ha ha. Too soon. Yeah, too soon.
Not the first person to make that joke.
Yeah. Jonathan says, stupid trial interrupting. More female runkle. I assume that's Danny.
Oh, thank you. You can
That
come
was the
check
funnest
out
thing.
more female runkle on my channel.
Which
I'm there
is
all the time. Danny on direct.
That was the fun thing with my Fuck It Friday stream we did 2 weeks ago, and
that
which
was hilarious.
means the next Fuck It Friday is 2 weeks from today. We had Danny on the left, Runkle in the middle, and Niklas on the left, and we sort of had like the timeline of the Middle Earth elves.
The progression.
I love that.
That was kind of fun. Yeah. And Julia 543 says, yes, Jeff, 2 stalking charges. They want directed verdict. 2 other charges want dropped. Well, I mean, that's what the defense wants. The prosecution argued against it, and the judge would never grant. It's almost never directed verdicts are almost never granted because the judge wants to leave it up to the jury. Julie O. Legal Vice says they were asking directed verdict for the stalking first. Yeah, and we also how that came out. The judge denied everything. Then why do this? So why make this? Because you need to preserve this for appeal. And if you didn't do this, this is such an automatic thing that if you do not ask for a directed verdict or whatever it's called in your particular jurisdiction, that is almost always a particular grounds for an ineffective assistance of counsel. Appeal. It's a formality. It's an automatic thing you have to go through just to preserve yourself and make sure you're ready for appeals. Boomer Millennial, thank you so much for the $5 super chat. Is it a mistake to require counts 1 and 2 dropped and leave 3 and 4? Could the jury use 1 and or 2 as a compromise to a lesser sentence and get time served? I assume you're talking about dropping the murder and hiding the body charges. The prosecution would never go for that. They want him to go to jail for the rest of his life. But
yeah, maybe the jury in a compromise, no, not enough evidence for murder, but we believe he did something, so let's get him for the stalking.
Yeah. And Captain Chromo says, the more I watch these trials, the more I hate DAs. Danny tried desperately to be a DA in Salt Lake City, and she did an amazing job because the DA there currently right now, Sim Gill, is an absolute fuckwit. Danny on, who has never run for political party whatsoever, threw her hat into the district attorney's ring simply on the grounds that the current DA, Sim Gill, was running unopposed. Danny, thinking no one should ever run opposed for anything, threw her hat in the ring, and she walked away with, was it 42% of the vote?
Yes, sir. Thank you so much, Jeff.
The endorsement of the governor, the attorney general of the state of Utah, the Fraternal Order of Policemen, the other policemen's union, the congressman for her district. She walked away damn near beating the incumbent guy in her first foray into the district attorney appeal for her first shot at the district attorney job. Danny is a super freaking hero.
That is incredibly impressive.
Stop. Oh my gosh. I love you so much, Jeff. Can I just have you hype me up like every day? Just come on my channel and I'll just have
hype you up
hype button.
any day. You know, you're my ride or die girl. Danny, I will hype you up any day of the damn week.
I freaking love you. Yeah, no, I agree though. There's so many bad DAs, and the one that I ran against right after the election, he decided to charge a woman who was killed in prison. Whether or not she was killed via the police intervention or not that's still up to debate. But what we do know is he decided to charge her post-death after the court already dismissed every charge against her and specifically stated in the docket that she was already dead. He went back and charged her with a drug charge so that it would look bad on her family so that the DA wouldn't have to pay out as much in the civil lawsuit.
Jesus.
Or the DA, I mean the county. So that's the kind
DA,
of corruption that I see going on all the time that really needs to stop. It's disgusting.
And the DA, when I graduated, like the very first case I was ever involved in was when I was a clerk the summer of my second year in law school, involved Sim Gill, who is now the DA. And he was a dick the first case I was ever involved in my entire life, and I've kind of had it out for him ever since then. And
We'll get him next time.
Danny's the real deal. She's the ride or die girl. We go to like really bad Thai restaurants in Salt Lake and some great bars and some other things. We hang out. She's the home girl. We like Danny.
I may even be out there with you, Jeff, soon. We'll see.
I can't wait. That'll be awesome. We need to get you, because Dan, she was here in 2012. She lived here in Korea in the same city I'm in 2012. She's the same law school alumni. She's a home girl from Utah, and there's some like connections. So Danny on direct is where you want to go for some awesomeness. And Andrew Hansen says, I've missed Schroeder too. It's a breath of fresh air after some other trial judges. There are better judges, but not better judge personalities. He's kind of lost a little bit since the Rittenhouse trial. I think he's getting old. He's like into his 80s. Gigi Beauchamp, right? Oh, what a bougie name that is. Wonder why Sadie, not prime suspect, being she is one in relationship and she claims to he's missing. She should be the prime suspect because she has a motive, because the defendant was planning on applying to the court for sole custody of the children, and then suddenly he's up on murder charges not too long after. Dun dun dun. There's a lot of things. I'm sure a lot of this is going to come up on the defense's case in chief. We'll just have to wait and see. Shannon 7. I can't unsee Steve Martin in the DA. Yeah, he's kind of a Steve Martin like hybrid with other people, depending on who you ask. There's several people you can be hybrided with, but Steve Martin seems to be the binding factor. Brian Miller, Lunchbox isn't working for the DA anymore. Yes, Krause is no longer working for the DA after the Rittenhouse trial, but Binger is still working for them. And the district attorney who is arguing these cases, he is Binger's boss. All the shit that Binger pulled during the Rittenhouse trial was probably learned from his boss who is prosecuting this case. Yep. This judge, Rittenhouse case, dismissed the gun charges at this point in the case. True. I was saying I had never heard of a judge dismissing charges on this motion for a directed verdict. What I kind of meant was like throwing out all of the charges. Some of the smaller charges will get thrown out, like Rittenhouse and other people do things. But generally, the judge wants the jury to decide, unless it is so egregious. But he didn't do that in this case. Oh my God. Here I am trying to pull up these few super chats. I'm already 352 regular chats behind. God dang it. It's so difficult. You guys are so awesome. I can't control it. Ben Ogle, we got you. Thank you so much. Oh yeah, that's what we said. The gun charge, the gun charges. I'm not drunk. Alyssa Ramirez, that's what I was going for. What is harassment under law? Yeah, harassment isn't a thing, really. You have the elements of stalking, which would come into play, but I mean, what? That's a great question. What is harassment?
So harassment is actually a thing, but more so, you see it more so in a civil context. Very, very rarely do states make that a criminal, put it in their criminal statute as anything other than an element of stalking or an element of another crime. And the reason for that is it's very difficult to prove harassment. And harassment is also very subjective in many ways. And so being able to meet your burden for a harassment claim is not easy. It does exist. And I suggest that you speak with your local attorney if you feel like you have been harassed.
Dun, dun, dun. C Shooter, what do you guys think happened that made the 3 witnesses not be needed now? There can be so many reasons why you call or don't call people as witnesses that it doesn't really serve any purpose to speculate. It would be pure speculation why certain witnesses get called and certain ones don't. But Chaos Coordinator Jeff, show them first defense witness when they show pic of the back of a van and then zoomed in on that speck of alleged blood. It is so small. That's why, like, any witness that interacted with this particular spot of blood said it is a pinprick. It is just a pinprick speck of blood. So small they couldn't tell what it was. Niklas Starow has reached 1,000 subscribers.
Congratulations. Woo!
Thank you. Thank you.
That's fabulous.
How many watch hours do you have?
Let's see here.
That's definitely the more challenging of the two.
Yeah, I'm looking in. As of yesterday, I'm at 983 public watch hours.
Just pull up some random stream and just let it run 24 hours a day. You'll get there.
Yeah, why not? I have a lot of Andrew Tate stuff to go through, so I might just have a 4 to 6 hours next week, just running when it started. Do a complete timeline.
So thank you all for getting Niklas up to 1,000 subscribers. Now just pull up his longest video and just put it on replay and just let it just put it on in the background and let it play for hours and hours and hours. That would be super awesome. And Here for the Truth says, tell Megan about the small weed op. Yeah, that was for those of you that didn't pay attention and weren't here. His 12-year-old, then 12-year-old, now 14-year-old daughter testified that he had exactly 72 plants growing in the hallway between the kitchen and the living room. He had a water system all lined up. He had a drying room. He routinely cut and harvested and packaged and sold the marijuana. But when they showed him a picture of just some buds in a Ziploc bag, she asked, well, "What is that? What am I looking at?" She couldn't even identify the marijuana that she had tested to this. She had testified to this massive growth operation. Bad look for the defense. Gigi Beauchamp right again. Is $2 enough to be considered sucking up? Everything is considered sucking up to me, and I love it. The Apostle Steve. I've missed giving Danny Banny a hard time in chat. Says
Oh, well, now you can come give me a hard time in chat all the time. That sounded so wrong. Fuck. I get so close to having a stream where I don't say inappropriate things.
Give it up. Just say appropriate things all the time and be proud of it. Yeah. And St. Nicholas, where is your red hat? We saw the red hat a minute ago, the Shriner hat. There you go. There's his red hat. Jolly old St. Nicholas. Jonathan, if the verdict is guilty, Wisconsin should be downgraded to a territory. We'll just kick it out. And Venray Lol, Aussie, even with a Guy Fawkes mask, you can't compare to Vice's glorious maritime mustache.
Nor would I attempt to, people.
Lame. All right. Well, that brings us up to date. Anybody have any questions before we pop on over to Aussie Overlaw'd's channel?
You have one more super chat I saw come through, Jeff.
I probably have a lot. I have to go through like 300 chats just to like dig up these things.
Okay.
Because that took a long time. While we're talk amongst yourselves here for just a bit while I scroll through chats like a madman.
So explain the hat, Aussie.
Oh yeah, so there were plenty of people that were asking. So this surprisingly, obviously it's tourist version of it, but this is a fairly frequently worn bush hat. These are actually wood for some reason. They're usually made out of cork because
they're made out of what?
Just take it from beer.
Cork.
They're made out of what? Cocks?
They were made out of cork.
Oh, cork. Okay. Not cocks.
Cork. C-O-R-K.
All right.
And basically they're designed to swing. And what they do is they keep bugs and insects and stuff out of your face because apparently seeing these move across your vision is less annoying than having to swat flies.
So you just have balls in your face to keep bugs away.
All the time. Yep.
I feel like you're lying to me.
No.
Nope.
No.
I'm
real?
genuinely not, but I'm taking this off because I just hit myself in the eye with one of them. So, oh god, my hair's terrible now.
Now, when I was a kid, one of my great friends, her name was Perry or Piper. She was from New Zealand, and I got one of the cool Aussie/New Zealand bush hats with the fold up snap thing on the side, and that was one of my favorite. That was one of my favorite hats when I was a kid. One of the bush hats. All right, next question. Anybody have any other questions while he's like scroll madly through these chats?
Was today at least more entertaining than yesterday afternoon?
We were. The trial wasn't, but we certainly were.
God,
yep. If you want to watch anything today, watch the first 6 to 7 minutes of this stream.
Exactly. Where we were talking about the Viking invasion of Ireland, it being it being St. Patrick's Day and all. As Niklas said, to paraphrase, he paraphrased the entire raping and pillaging of Ireland as the Vikings just stopping in to say hi to the Irish.
That's like the most Northern Scandinavian description of anything they do.
Just stopped in to say hi to the Irish.
Say hi. We didn't, you know.
I can't just every word the first 5 minutes, and the YouTube could be deleted or something like that. So I short circuit and just say hi.
The first 10, 15 minutes of this show was just the most hilarious. just the Vikings popping in to say hi to the Irish.
The Vikings are just really friendly. That's all. They're just friendly neighbors, popping in to say hi to everyone for a couple thousand years. Or a couple hundred.
Just popping in for a cup of sugar, and everything else.
Collected 5 more super chats here, and then we can. Are you up and running yet, Aussie?
Yeah. Waiting for you.
Oh, you're already live?
Yeah.
We got to figure out like this new thing where you can like allow guest streaming and stuff. We need to figure that out one of these days.
Yeah, so I want YouTube to hurry up and move the whole collab from the because you can have 2 streamers now. If you do it through your mobile phone, you can both be sharing the same stream and streaming to your.
But
YouTube
also,
channel.
like as of this week, StreamYard has also initiated this guest streaming thing where you can have a guest on, but you can both be streaming on your channels at the same time.
Mm-hmm.
And so it would make this transfer a lot easier, but we kind of have to figure that out one of these times here. Shannon 7, Jeff, thank you for introducing us to so many awesome people. Let me tell you the awesome people are here. Niklas is an awesome person. Danny is an awesome person. Chandler is an awesome person. And Aussie, like awesome is the first part of Aussie, so he's obviously Aussie awesome. These are seriously awesome peeps. Loving your panels, sub to all, and awesome chat. Cannot agree more. These are my peeps here. Aussie, even with the guy, we already read this one. You get a twofer. Glorious mustache, blah, blah, blah. End of stream. Okay. Phlox, Mocha Dick Poon, XOXO. What an amazing panel. Hello, waifu. That's to you, Danny, I'm sure.
I know.
Yeah, I know.
I know who I am.
Yeah,
I love
hi,
you,
Chandler. Hi, Aussie Bear. Hi, Niklas. Hi, Spicy Jeff, XOXO.
G'day, Flux.
Flux is my
We love you, Flux. And for those of you that are keeping score, about 7 hours from now, I will be on Flux's channel where we're going to be talking about the unexplained, supernatural, missing, whatever conspiracy theory shit. There's no topic. We're just going to be talking about shit. And Danny may be there. Danny on direct may be there if she's able to arrange her schedule accordingly.
I will try not to get drunk before that stream.
It's guaranteed Flux and I, but Danny on direct is a possible viable number 3.
Can't wait to get spooky.
Yeah. Arian the vegetarian. Hey, long time no see, Arian. How are you doing? Danny, my old coworker. Oh, okay. Danny, my old coworker turned. I was like, what? Okay. Danny, my old coworker turned up. A longtime friend is Mark Shirtliff's adopted daughter. Wait a minute, what?
Mark Shirtliff has an adopted daughter, and that adopted daughter is her coworker.
But you haven't worked with Arian the vegetarian?
No.
Okay.
Mark Shirtliff's daughter did. So for those who don't know, Mark Shirtliff was the old AG here in the state of Utah. He was targeted in a sting operation to bring him down. They raided his house, and they came in with like sniper rifles and scopes. And this poor girl, so Mark Shirtliff, they had planned it so that he was already in DC at the time that they would conduct the raid. Well, he came in and like his 17-year-old daughter is standing there like in her underwear and everybody's like pointing guns at her. They have no clue what's going on. And all of it turned out to be fraudulent. He was acquitted on every single charge that was brought against him by the DA and the incoming AG. Talk about some drama. There was drama. So yes, Sim Gill is a POS. I absolutely agree.
Yeah, and that's why Arian says, I know what a piece of shit Sim Gill is. So mad you didn't beat him.
Oh, thank you. That means
And Nick Naylor, what's with the short necks? Get me some long necks. Absolutely. We like long necks. Noses and long necks. Those are my fetishes. If you know, you know. You can appreciate it. All right, we got one more super chat, I think, here. And then Ken's counseling couch says, Irish seeing Vikings first time. Senpai is home. That too. I think we're caught up. Yep, we are caught up with the super chats and everything. Oh my God, this has been a wild, weird, wacky, fun stream. Just too much excitement, too much fun going on. You guys are the best. And I have like 4 of the coolest people on the entire YouTube platform here. Niklas Starow, Danny On, Chandler Remington. Chandler, you need a YouTube channel. Just get it going.
I'm working on it. I actually have a YouTube channel and I have like 7 subscribers, but there are no videos. I just have a playlist of all of my stream appearances. So if you guys want to subscribe to me, I'll send a link to Rose or whoever needs one. And I'm working on it. So it'll be fun.
As I told Danny when I convinced her to do this, just turn that switch to on and start talking.
Okay. You know what's going to happen? You're going to quit your daytime job at 6,000 subscribers and be like, yeah, I can do this full time. This is a great idea. This is a wonderful career alternative. And hopefully it is. So please come subscribe and send me your money. Send me all your money. Love you guys.
I'm going to head over because I've got like 115 people.
All right.
Revolting because I've been up for 20 minutes. It's just saying starting shortly. So
and I will dump over you two here in just a quick second.
All right, so links in private chat. I shall see you all later. Cheers, guys.
All right. And what we're going to do now is we're going to shut this stream down with 1,834 people currently watching. We can shut our stupid poll down. Let's see what we've got here. 63% of you say he's innocent or not guilty. 26% of you say hung jury, and 11% of you say guilty. You 11% are hopeless. You're wrong, wrong and hopeless. And coming in at the wire here, Law and Lumber, there is no time like the present, can attest. Thank you for that, Rob. You're deeply, deeply appreciated. You need to come on some of these streams, right? You just come on like the Fuck It Friday streams when they're both so liquored out of our gourds that I can barely remember you even being on my streams.
Rob, I loved having your super chats. I love seeing Rob in the chat. It's really fun. And I always wish I'm just like, Rob, come on, come join us. It would be great. Hopefully one day that would be fantastic.
Yeah. Some people have jobs. All right. So what we're going to do is we're going to shut this down as soon as I've got to like arrange this so that we can all get automatically redirected to Aussie Overlaw'd. It takes just a quick second here. I'm going to my channel content. Got to go to this video. Then we got to go to the customization screen. We didn't have to do slow-mo today. That's pretty good. Redirect. We got to go search videos for other channels. Allegedly, there we go. Aussie Overlaw'd. And we are redirecting to now. Here's the thing, I think we've kind of figured this out. You have to have auto play on to get automatically redirected to whoever you're redirecting to, which is Aussie Overlaw'd in this case. If you don't have your auto play turned on, you're just going to be left alone. And in that case, there's going to be a little box up here at the top of the chat screen saying, go on over to Aussie Overlaw'd to find out all the excitement that's happening there. If even that doesn't work and you're just left like a wandering spirit in purgatory, just go figure it out for yourself. Go to Aussie Overlaw'd's channel, search for him, and go to the live stream there. Mods, thank you for being so super moddy. You guys are the greatest. You're the best. And thank you to the Vice Squad chat. The Vice Squad is the greatest chat on the entire internet, hands down, bar none.
Agreed.
Thank you so much for the generous super chats. We'll be back on Monday for Maritime Monday, and then the trial stream will continue. Thank you, Niklas, for being here. We'll see you over on Aussie Overlaw'd. Go to Niklas Starow, Union Rep Labor Law. Subscribe to him. Danny on Direct, my home girl, the ride or die girl, the most awesome girl on the internet. Danny on Direct. Like and subscribe to her. And then Chandler Remington, the other ride or die girl, the greatest, most awesome girl, most based and unbreaded chick on the entire, Twitter platform. Go to Remy, REMY_legal. That'll get you to Chandler Remington, paralegal extraordinaire and future, for some reason, law student. Subscribe to her.
Thank you so much, Jeff. That was like the sweetest thing I've ever heard. You were so incredibly kind, and I'm just so happy to be here. I'm honored.
You guys
I love
are
seeing
awesome.
Danny again. This is awesome. It's been great, like, just to be in chat with all of these really amazing people during this trial. I've just loved this experience. So thank you so much.
Well, let's all meet up over on Aussie Overlaw'd in 3, 2, 1. Law Racks out. Bye now.